1.
None appears dismissed from the process.
Weekly list old matter item number 2.
May I please your lordships? Lord, it's a covered matter. I have given the order, my lord. I have gone through the entire. In fact, I have not traced out my brief. However, I have gone through the lordships brief and have found out that the main issue is whether the steel and cement supplied by the employee to the contractor, whether it constitute a sale or not. That is on recovery basis. So your lordships have already held.
So simply say in view of the orders, it's disposed of.
Your Lordship, your Lordship may kindly turn to page 3 of that order, your Lordship's order. In your Lordship, 3 lines, just in that view of the matter, the view taken by the tribunal is just and proper.
Correct.
Your Lordship, that is all right. The next line, however, it is open for the petitioner to apply for setup if there is double taxation. So far as this issue is set up, apply, already tribunal has restored the matter. So it has said, your Lordship may kindly turn to page 110. The Learning Tribunal has stated that to correctly determine the TTO and tax payable, the assessment are remanded
So
back.
anyway, we don't interfere.
Your Lordship,
Same thing.
You say in view of the order dated 12 December 2018, passed by this court in STREV 12 of 2003, bracket Nalco Limited versus State of Orissa, bracket. This revision petition is dismissed.
Weekly list item number 3.
None appears dismissed from the process.
Weekly list item number 4.
your Lordship, item,
So item number 4, the only question involved is Milord's Lal Dantumanjan. Whether it is drugs or toiletry goods, that's the only question, Milord.
Lordship, the tax effect is 23,000.
Hardly
That I know, but there is
It's all right, so then we'll keep the question of law open. We say with the tax effect being insignificant, the court is not inclined to interfere. However, the question of law is left open for decision in some other appropriate case. All right.
Weekly list item number 5.
My lord, item number 5 is subsequent STRB revision. My lord, pass this order. This same order may be followed.
Your Lordship, since tribunal has restored the matter, your Lordship has not interfered. The same order.
Yes. Yes. All right. Same order.
Weekly list item number 6.
Because in item 6, I met at the outset statements. The delay of 134 days as per the office report, and steps have not been taken.
All right.
The tax impact itself is also around 23,000.
All right.
The question
Steps
of
have
law
not
may
been
be-
taken regarding limitation. And defects have also not been removed. The court is informed that the tax effect is also insignificant. In that view of the matter, the court is not inclined to interfere. The petition is dismissed.
6.
Very good.
Thank you.
Weekly list item number 7.
Well, item number 7 is the tax effect is 8,414.
All right. The tax effect being insignificant, the court is not inclined to interfere. The question of law, so left open.
Weekly list item number 8.
May I please, my lords? This matter is covered by your lordship's judgment, my lords. May I just hand over a copy?
Yes.
The issue, my lord, is that whether an IPR exempted unit will also be eligible for the concessions as available to it under the General Sales Tax Act. My lord. Here, the fact, my lord, remains that the petitioner admittedly is a IPR exempted unit, my lords, and it had sold its products on the strength of Form 4, my lords. So Form 4 is taxable at the rate of 4%, my lords. So if my tax liability is calculated at the rate of 4%, my lords, my fixed capital investment, before that, my lord, I will just say this, that here in this particular case, the petitioner's unit belongs to Zone C, my lords. As per the IPR, my lord, I'll get only 60% of the fixed capital investment. That comes to 32 lakhs some odd, my lords. So if my tax will be calculated at the rate of 4%, my lord, I get this exemption or exhaust this limit, my lord, at a longer period of time. If I forgive Form 4, my lords. But if it is calculated at the general rate of 12% applicable to goods, my lord, I exhaust this limit earlier, my lord. The question which arose, my lord, was whether an exemption as well as a concession can simultaneously be applied for a IPR unit, my lords. This matter, my lord, was directly before your lordships in this Louis packaging case, my lords, where your lordships have, I just must straight away take your lordships to the question of law, which is at 484, my lord, page 484, my lords. Paragraph 6. Lordship copy?
Yes.
Whether for the purpose of computing the ceiling of exemption of sales tax, the authorities are correct to compute it at a rate of tax for goods which it does not purchase or sell, which is higher, and reject the rate applicable to it for what it purchases and sells. B, whether the two issues in para A above are correct, and if so, the one that favors the SSE was correct to be rejected. Then your lordships would appreciate. I'll just place this undisputed facts, my lords, so that your lordship will be able to, because the facts are almost similar, my lords. The petitioner is eligible to get benefit under the IPR 1996. The petitioner is a new industry and started commercial production after 1st of April 1997 and was granted permanent registration on May 14, 1997.
What is the tax effect in your case?
My lord, tax effect will be, my lord, more than 10 lakhs, my lords. Your, my lord, the tax effect is not very much German, my lord. What has happened, my lord, if my tax liability, admittedly, my lords, I have accepted Form 4 on the sale of my goods, my lords. But unfortunately, the authorities below, they have calculated my tax liability at the rate of 12%, which is applicable to goods, my lord. So I exhaust my fixed capital
But
investment.
what happens? Your tax liability, you have to seek a refund, is it? You've already paid the excess tax.
I have paid the excess tax because the liability, what has happened, my lord, in the first assessment, my lord, some liability was found due, my lords, because I had crossed the limit. Subsequently, I went up in revision, the first appeal, my lord. That matter was remanded back. Then in the set-aside order, my lord, the tax was computed at the 4%, my lords. When I went up, my lord, to say that this 4% and the balance 12% should also be at 4%, I went up in first appeal. The first appellate authority, without considering my claims, again set aside the matter. Against that order, I went up to the tribunal, my lords. The tribunal, my lord, if the lordship would kindly turn to page 35, what the tribunal holds, my lords. Para 4, my lords.
Yes.
Running page 35. We have heard the arguments and counter arguments of both the sides and have gone through the orders of the fora below vis-a-vis the materials on record. Undisputedly, the appellant's unit is an SSI unit set up under IPR 1992 and eligible for exemption of tax on purchase of raw materials, spare parts, and machineries, and on the sale of finished products for a period of 5 years from the date of commercial production, as per the ceiling limit of 35 lakhs 12,000. That is 60% of the fixed capital investment as per entry number 42 of the tax-free schedule under the OST rules. The dispute of the appellant is confined to the calculation of tax rate at the rate of 4% on the sales turnover of 10 lakhs 9,038 against Form 4. And the same should be given adjustment against the limit of tax exemption benefit available to the appellant's unit. On this score, the learned STO has calculated tax at the rate of 4% on the said turnover on sale of against Form 4, but no adjustment of 40,362 from the exemption benefit was allowed by the learned ACST, who rather held that when the appellant has not paid tax at the rate of 4% on the sale turnover, computation of tax should be at the rate of 12% on the said turnover along the surcharge. Here we are inclined to observe that when the finished products of the dealer are exempted from payment of sales tax up to a certain ceiling and for a prescribed period, the dealer need not sell the goods through statutory forms meant for purchasing goods at concessional rate up to the that ceiling, and full rate of tax on sale of such goods need to be calculated to compute the benefit of exemption availed by the dealer. Similarly, for the purchase of raw materials, spare parts, and machineries, the dealer need to purchase the goods intrastate in Form 1D92 free of tax, and he should abide by it. And if he purchases goods in Form 4, the full rate of tax at the rate of 4% is to be calculated to compute the tax benefit availed by the dealer to the extent of the prescribed limit within the prescribed time limit. The dealer is not entitled to avail both the benefit of exemption and concession till it exceeds the prescribed ceiling because it runs negatory to the stipulation laid down in entry 42 of the tax-free schedule under the OST rules. Then they quote certain decisions which are, in my humble submission, not applicable to the case. Then ultimately, my lord, they come to hold that resultantly the appeal is dismissed. So the basic premise which weighed with the learned tribunal was that a concession and an exemption cannot simultaneously be availed by an IPR exempted unit, my lords. And this Louis packaging, my lords, in my humble submission, my lord, is directly applicable. And your lordship may kindly turn to page 488, my lord, paragraph 14 of that judgment, my lord, of Louis packaging.
No, so notice is not even gone in this then.
It's just a covered matter, my lord, with great respect, my lords.
What do you say?
Your Lordship,
He says it's completely covered.
Your Lordship, let me go through the matter, Your Lordship. Let it be in the board, Your Lordship.
Okay.
Your lordship pass it to I would.
Next week, Your Lordship, let it
Or,
be.
You see, Mr. Karel.
Because here, Your Lordship, the ceiling has been exhausted. Your Lordship, that is the issue.
No, but here-
Let me examine.
Here the calculation, my lord, is if my tax liability will be calculated at the rate of 4%, my lord, I enjoy that ceiling limit till 5 years.
Because
But I exhaust that if it is calculated at the rate of 12%.
exhausted means prior period. You have exhausted in the prior
I
period.
have not.
The dealer has
I have not.
been
That
exhausted.
is why in Louis packaging also they have remitted back the matter to the sales tax officer. They have laid down the law that these two concessions and exemption.
The other thing is to send it back to the tribunal in view of this judgment and let the tribunal examine if this judgment applies.
Your Lordship, please.
No, Here,
Your Lordship.
your lordship, I'll be obliged, my lord, but your lordship would see that ultimately also in this case,
So the tribunal did not have the benefit of this judgment.
minus.
So it's a
Your
subsequent
Lordship.
judgment.
The tribunal has gone through other cases of Honorable Supreme Court, different case law. So
But
let
this,
it be
specific-
remanded
This,
along with this case.
this specific case was not before the tribunal.
Yes.
Mr. Karel and counsel, the petitioner points out that the basic premise on which the tribunal proceeded to hold that the petitioner cannot avail of both a concession and an exemption at the same time. Petitioner, who is admittedly covered,
Weekly list item number 13.
none appears dismissed. No.
Weekly list item number 14.
Item number 14, Your Lordship, 7 months delay.
There's an inordinate delay which has not been explained. The application for delays, condition of delays dismissed, consequently no steps have not even been taken for such delay.
Your Lordship, petition has been filed, but the explanation is not satisfactory.
All right.
Your Lordship may not record my concession.
No concession
Yes,
here. This is the explanation not being satisfactory. The court is not inclined to condone it. The petition is dismissed.
Weekly list item number 15.
9 months delay.
Delay of 9 months has not been satisfactorily explained. MC number 244 of 2008 is dismissed. Accordingly, the provision is dismissed.
Weekly list item 16.
2017 days delay.
Sorry,
2017 days delay.
2017 days delay, not satisfactorily explained. All right.
Weekly list item number 17.
So item number 17, my lords.
Yeah.
Yes, next year, one is the assessment order, is handwritten, my lords, script of the assessing officer, my lords. My lords, your lordship, kindly bear with me, lords. I will not strain my lord's eyes to that document, my lords. I will forgive that, my lords. Because I will be only taking your lordship's attention to tribunal's order, my lords. But the question which is framed in this case, so lordship, kindly see at page 20, my lords. Only one question, my lords. I'm sorry, that is at page, at page 16, 16, my lords. Two questions are there. So whether in the facts and circumstances of the case, the conclusion will run in tribunal holding a loan transaction as purchase suppression is lawful and proper when the same is based on no evidence. B. Whether in the facts and circumstances of the case, the petitioner having denied the alleged transaction, the revenue has to disprove by any cogent evidence and record to justify its conclusion of purchase suppression. So this proposition is based on two judgments, one of our High Court and one of Allahabad High Court. The issue involved in this case is Whereas in assessment, 12 reassessment, whereas original assessment accepted, reassessment. Whereas it is reported that the petitioner has received 5,36,000. Whereas the contention all through that there is it's a loan transaction which I have given 5 lakhs to one party of Guwahati, the name is also there, and 36,000 interest component. And in the books of accounts of both winners, the petitioner and Guwahati party, this is reflected, and this was also disclosed to Income Tax Department. Whereas this was also accounted for in the winners' books of accounts, and return is disclosed to the Income Tax Department. You will also kindly see the findings of the Learned Tribunal at page 28 by now, at paragraph 4. We have heard Mr. R.S. Agarwal, Learned Counsel for the Appellant, and Mr. B. Ekka, Learned Assistant Headquarter Appeal, and have gone through the grounds of appeal, assessed order, improved order, written submission. The appellant, the order of assessment, improved order reveals that the vigilance team visited place of the appellant and found that the appellant had purchased material of 5,36,875 from Ramesh Kumar Sikaria of Guwahati, but had not entered in the purchase register. At the assessment stage and at first appeal stage, the appellant had explained that he had given a loan of 5,000 to Mr. Sikaria, who had returned the principal along with the interest of 36,875 through bank account, through bank check, and he had disclosed this fact in the IT return. The Learned Counsel for the appellant produced one letter from Sikaria, Ramesh Sikaria of Guwahati, by annexure 1 of the written submission addressed to the appellant, where he had given a statement of account of the appellant appearing in the books of Mr. Sikaria. This document now, what Learned Tribunal said, this document doesn't prove that the appellant had given loan of 5 lakhs to Mr. Sikaria, and he had returned it along with the interest of 36,000 and so annexure 2 submission is a self-prepared statement of appellant showing details of interest account for the Article 1-2, whose name many persons have been mentioned. Here it will be mentioned here, there is nothing to show that Savitri Industries is authorized to carry on business of giving loan. In such circumstances, forum below rightly discarded. Now, Milords, now he has enhanced to the 4 times, and tribunal confined to the actual loan transaction. My humble submission is that it's a right rule of law. There must be completed sale. This honorable apex courts in the Rajasthan Chemist Association, which I have read in the petition itself, says that Deher's completed sale, that cannot be any levy of tax. This is number 1. Secondly, in order that the complete sale must take place, Constitutional Bench of the Honorable Supreme Court, I have also pleaded in my petition in the case of Ganan Kankali and various judgments, saying that 4 ingredients must be satisfied so as to culminate in a completed sale. If one of the ingredients is not satisfied, there will be no sale in the eye of law and no tax can be attracted. This also I have pleaded, both decisions I have given. And thirdly, whenever any allegation of suppression is made, it is the alleger who has to say specifically what I have purchased, which I have not accounted for. So what is the bill, what is the quantity, what is the amount, nothing is belongs. And when the law is that, when the assessee in response to allegation made against the dealer says that he has not effected any such purchase or sale, the onus to disprove shifts to the revenue mirrors. That is law. Initial onus is always on the dealer mirrors against whom allegation is made. But while discharging that onus mirrors, if the assessee says that I have not effected any such purchase, the onus to disprove shifts to the revenue. That is what precisely the Honorable Allahabad High Court has stated in Mittal and Company case 16 page 42. Whereas I have sent to your Lordship a copy of that judgment. And this position of law is also accepted by our High Court, Milords, in the case of K.B. Muhammad, with a reported judgment. Whereas in that case, of course, someone was initiated. In this case, there is no need to issue any summon because I have produced all documents, and the assessing officer, First Authority, as well as Learned Tribunal, without finding anything wrong or any.
Lordship, with great respect to my Lord Senior, I think this particular question is a question of fact, Your Lordship. There is no announcement, nothing has been made, only the suppression amount has been added, Your Lordship, 5,36,000. And Your Lordship, for the 3 forums have considered the grievances of the petition, Your Lordship. For the first time, he has stated that this is a loan transaction. Your Lordship, if it is a loan transaction of the proprietor of the farm to the person, Your Lordship, why this transaction has been recorded in the funds account, Your Lordship? If at all, Your Lordship, the First Appellate Authority as well as the tribunal has stated the same thing, that Thus, Lonin STO confronted the report of the appellant at the time of reassessment. On confrontation by the Lonin STO, the appellant took a stand that this was a loan account transaction. He submitted that he had given loan to Ramesh Kumar Sikaria, so and so, has returned the money through bank check. He further contended that there is no element of purchase. The Lonin STO observed that if it is a personal loan, the same should be maintained in personal account, but not in the firm account. So he rejects the contention of the appellant and raised the impugned demand. And subsequently, before the first appeal, also the same plea has been taken. And before the tribunal, my respectful submission before your lordship is that.
No, but in both their returns, the person, the present assessee's books of accounts plus the borrower's books of accounts,
Your lordship.
both reflect this as a loan transaction.
No, your lordship, the borrowers in the first appeal stage. In the first appeal stage, he one after another. Your lordship, there was the investigation fraud case report. Before fraud case report, he has not submitted anything. Before the assessing officer, he has stated that it is a loan account in the farm account. In the first appeal stage, he has submitted that we have disclosed in our balance, in our books of accounts,
No,
balance
he's
sheet.
not put out a new case or anything. This case throughout has been, it's reflected in both their books of accounts. The assessee's books of accounts as well as the borrower's books of accounts.
Your lordship, that's right. But your lordship, your lordship may kindly turn to the tribunal's finding, your lordship, at page, internal page 2, paragraph 4.
Yes.
We have heard, Mr. Your lordship, the next page, the last line. Here it may be mentioned that there is nothing to show Savitri Industry was authorized to carry on business of giving loan. So in such circumstances, the forum below had rightly discarded the stand of the appellant that he had given loan to Mr. Sikaria and received back it with interest. Here, purchase suppression has been rightly established. Now it is considered whether on account of this suppression, enhancement of GTO made is justified. Your lordship, so far as the enhancement that has been deleted, only that portion has been added, your lordship, confirmed by the tribunal. The learning council for the appellant.
Where is purchase suppression? That is what I was wondering. My lords also must be. What is purchase
material
suppression?
for that, please? There's no material to derive this conclusion that there is purchase suppression. You must have something contrary to what he's showing, right?
My lord.
Decision I have given, probably that must have reached your also.
Yeah.
Mittal and company that your lordship may see relying on this. Paragraph starts from relying on this, standing counsel argues. If your lordship permit me, I will place one paragraph.
Yes.
That's relying on this, standing counsel urges that it was for the assessee to establish that no sale within UP was made during this year. No doubt the initial onus is on the assessee to show that no sale was made within UP during the year. But the question is how this onus is discharged. For establishing a negative fact, no evidence will be adduced. When the assessee denies the factum of UP sales, the onus was shifted to the revenue to disprove the contention of the assessee, and that not having done, the authorities below were not right in having presumed the UP sales. For the reasons the turnover of UP sales determined at rupees 24 by tribunal has been deleted, this dispose revision relating to UP sales tax act.
All right.
And this is also
Correct.
accepted by our in KV Mohammad's case. In paragraph 4 also, this Honorable Court has accepted this proposition of law.
All right. You say the present revision petition by the SSC is arises from an order dated 10th April 2008, passed by the Orissa Sales Tax Tribunal. Tribunal. In essay number 357 of 2006-07, whereby the SSC's appeal was dismissed and the order dated 27 February 2006 passed by the Assistant Commissioner of Sales Tax, (ACST), Cuttack 1 range, confirming the assessment made under Section 12 (8) of the Orissa Sales Tax Act 1947 for the accounting year 2001-02, raising a demand of 194,748 and penalty of 139,941.54 was affirmed. Paragraph. The background facts are that the petitioner had purchased paper and other materials from within and outside Orissa and had prepared exercise khata. Full stop. The original assessment was completed by raising a demand of rupees 25,048. Full stop. Thereafter, it was reopened under Section 12 (8), the OST Act, on the basis of a fraud case report submitted by the Vigilance Department, in terms of which, according to which, the SSC had procured goods worth 536,875 from one Sri Ramesh Kumar Sikaria of Guwahati, but had failed to reflect it in the purchase register. Full stop. The explanation offered by the SSC was that he had given a personal loan of rupees 5 lakhs to Mr. Sikaria and had recovered back the principal amount together with interest in the aggregate sum of rupees 536,875. Paragraph. However, the assessing officer rejected the said contention and termed the loan transaction as a purchase suppression. Full stop. Accordingly, the gross taxable turnover (GTO) was enhanced by
21 lakhs 72,000.
150. That was 4 times the alleged suppressed amount. Full stop. On this basis, the tax amount was recomputed and penalty was also imposed. Paragraph. The SSC then went before the ACST, which was rejected. Thereafter, the SSC went before the tribunal, which by the impugned order has rejected the second appeal. Paragraph. Admit the following question of law as frame for consideration. Were the tribunal, the ACST and the STO justified in proceeding on the basis that the alleged loan transaction of the SSC was in fact an instance of suppression of sales, suppression of purchases? Full stop. Question mark, sir. Question mark. It may be mentioned at the outset that in the impugned order, the enhancement was restricted by the tribunal to the actual suppression, actual alleged suppression, that is the sum of rupees 536,875. Full stop. The penalty at 1.5 times the tax due was asked to be added to the extra tax demand. Paragraph. This court has heard the submissions of Mr. Jagabandhu Sahul and senior counsel appearing for the petitioner, Mr. Mishra, Suril Mishra Leonard, is additional standing counsel for the department. Paragraph. Mr. Sahu relied on the decisions in Mittal and Company versus Commissioner of Sales Tax, 1998, 69 STC, 42 Allahabad, and KV Mohammed versus Sales Tax Officer, Cuttack 2 East Circle, 1998, 109 STC 530 Orissa. How can both be 1998, sir? I think 1988, the first one is 88. not 90. First one is 1988. Mittal and Company.
Oh, 88, sorry. Yes, yes. I'm so sorry.
It is submitted that there cannot be an inference that a loan transaction is actually an instance of purchase suppression without there being any material in support of such inference. Full stop. It is further pointed out that both in the books of the SSC as well as Mr. Sicaria, the transactions were reflected as contended by the SSC, and this could not have been ignored by the authorities. Paragraph. Mr. Mishra, on the other hand, supported the impugned orders of the authorities and submitted that there was nothing to show that the SSC was ever authorized to carry on the business of giving loans. And therefore, the inference drawn that this was purchase suppression was justified. Paragraph. It is seen from the impugned order of the tribunal that a letter was produced from Mr. Sicaria and placed before the tribunal, in which the statement of the account of the SSC is appearing in the books of Mr. Sicaria was enclosed. Full stop. It is further seen that on the part of the SSC, material was placed to substantiate the contention that the transaction was in fact a loan transaction. Full stop. In Mittal and Company versus Commission of Sales Act, it was rightly pointed out that although the initial onus is on the SSC to show that no sale was made, the question arose as to how the SSC is expected to discharge that onus. Full stop. As rightly pointed out, open quotation, for establishing a negative fact, no evidence may be adduced. Unquote. Once the SSC had denied the factum of sales within UP, in that case, open quotation, the onus was shifted to the revenue to disprove the contention of the SSC. Unquote. Since in that case the revenue failed to disprove the HSC's contention, the addition made to the taxable turnover for presuming sales, was set aside. Paragraph. As far as the present case is concerned, again, the SSC cannot be expected to negatively prove that there was no purchase suppression. Full stop. The SSC, in fact, placed materials to show that the transaction was a loan transaction. Full stop. If the department was to doubt it, it had the onus then shifted to the department to show that there was in fact a transaction which mimicked a purchase suppression. Full stop. With the department not having discharged that onus, the authorities below, including the tribunal, the ACST and STO, were in error in proceeding on a presumption that it was a case of purchase suppression. Paragraph. Consequently, the court answers the question framed in favor of the SSC and against the department and sets aside the impugned orders of the tribunal, the SCST, and the STO. Full stop. The revision is allowed in the above terms, no order systems.
Weekly list item number 18.
Item number 18 and 19, my lords. In this case, my lords, I have already served a copy on my learned friend because certain notification copies are not been annexed, my lords, I have given. Your lordship, my friend may like to go through, your lordship, I will check up next week, my lords. Otherwise,
It is already this issue has been decided, Your Lordship.
no,
Before much before.
decided, but that is a judgment which I have referred. Our High Court decision case of Mansfield Electronics. If I friend what to argue, I have ready, my lords. In Mansfield case, my lords, this honorable court, my lords, relying upon two judgments of the apex court, Bakul Oil Industries and Purnam Oil Industries, said that, my lords, whenever there is a notification of the government granting exemption, my lords, there cannot be abridgment within the period tenure of exemption. It can be prospective. Question therefore raised in this case is whether the notification withdrawing exemption prospective or retrospective. That's the only question to be answered. But even though the withdrawal notification is held by the honorable apex court to be within the jurisdiction of the government, but this question has not been answered, and I have also quoted the decision of the honorable apex court, where our honorable apex court said that this point has not been argued. Had this been argued, the outcome would have otherwise. Well, if your lordship permit me, I can start argument. Otherwise, your lordship may kindly check up next.
Just I can add one line. With permission of my Lord and Senior. The entire issue in this case is that the exemption notification has been withdrawn with effect from 30th July 1999. So the petitioner's case is that he has been declared to avail the benefit for a period of 7 years. In mid of the period, that notification has been withdrawn by the government, Your Lordship. So that withdrawal notification has been challenged before this honorable court that this should not have been withdrawn in between the period, Your Lordship. And that withdrawal notification.
No, probably my learned friend wants to open the case.
Line, with your permission, just one line.
Otherwise, you will leave my lords, I can start argument.
Has been declared as valid. Against that judgment, the petitioner has gone to Honorable Supreme Court, and Honorable Supreme Court has confirmed that order. So after that order, Your Lordship, my Lord and Senior, Your Lordship, because that is the only issue, that is the sole issue here.
Question, that is not the issue. That is not the issue. I am also aware of the judgment of Honorable Apex Governor Packers, which I have pleaded in the petition itself. It is not that nothing is considered. Because despite of that, I have brought to that. There can be two things. Either the matter can be referred to larger bench, or it can be sent back to Royal Tribunal, who has not considered the pleadings from paragraph K to R, which has not at all been considered. The Royal Tribunal has not been bothered to consider all the matters. With great respect, I humbly say.
No. What is the other issue involved? It's only about the validity of the withdrawal of the exemption, correct?
The issue is, whether the exemption, withdrawal of exemption notification, there is no quarrel that government has power to grant exemption, and also under General Clauses Act, applying the principle, he has also power to withdraw exemption.
Right.
The power to withdraw exemption is also upheld by the Honorable Apex Court.
Right.
But the only question is whether the grant of exemption notification and withdrawal thereof can be prospective or retrospective. A bench of this honorable court, which has not been brought to the notice of the Honorable Apex Court, that has been also mentioned itself, which I have quoted, said that there can be withdrawal, but there cannot be abridgment from grant of exemption during the period of exemption. But supposing the exemption is for a period of, say, 5 years, So, once exemption is granted, after that, the government has every power to withdraw, may not grant any further exemption. Government has every power to do that. But if somebody, in the midst of enjoyment of exemption, in the midst of continuance of exemption, this honorable court said, relying upon two honorable Apex Court judgments, that there cannot be abridgment of grant of exemption. That is what precisely. So, therefore, your lordship in this case will consider whether.
But if the Supreme Court, if the Supreme Court affirmed the retrospective withdrawal of the exemption, then this argument does not hold.
Exactly, that has not been done. Your lordship is very correct.
Not particularly retrospective, Your Lordship. The exemption has been withdrawn by the government on dated 30th July 1999. From that day only, that withdrawal has been accepted, Your Lordship. That withdrawal has been accorded. Not before that previous period.
It was not given retrospective.
Not retrospective. My Lord and Senior's argument is that since I have availed for a period of 7 years, so in between that 7 years, I have availed 6 years. 1 year is ahead. and in between that after 6 years, the withdrawal has been made. So only the withdrawal should have been made after 7 years.
Which means
So
there's
that
no
is-
withdrawal at all.
That cannot be, Your Lordship, because after it has already been decided by Honorable Supreme Court.
Correct, correct.
Only if your lordship will see para 11, page 11 para Q minutes. And see judgment court to the
Yes.
As para Q, that the Honorable Supreme Court in the case of Mr. Jagannath Packer versus State of Orissa and various other similar petitions in SLP civil number so and so by order dated 4/3/2005 had recorded a finding which may be reproduced below. It was also sought to be submitted that the notification dated 37/99 did not take away incentives or concessions which were already granted by the earlier notification. It was submitted that this notification only operated prospectively and only applied to new industries who would now not get any incentive or concession after the date of notification. Even otherwise, we find that no such contention had been raised before the High Court. When we asked if any such contention was raised before the High Court, all that could be pointed out is the following paragraph from the impugned judgment of the High Court. On our view, these submissions do not cover what is now being argued for the first time. Let's, Your Lordship, now make kindly for a moment see paragraph O, my lords. Paragraph O, page 10. The Honorable Orissa High Court, in case of Mansfield Electronic versus State of Orissa, in judgment dated so and so, OGC number so held that the benefit of exemption cannot elapse till the period for which exemption is granted by the state government under the notification. The Honorable Court, while dealing with an identical proposal, held that an exemption which was granted by one notification to remain operative for a period of time as specified in that notification
No,
will
but
continue
this is contrary to the Jagannath Packers.
Exactly, my
No, this is contrary to Jagannath
And
Packers,
this is-
I'm saying.
After that judgment, after recording that judgment, Honorable Supreme Court has dismissed in Jagannath Packers.
Therefore, Honorable Supreme Court said that such a proposition has not been advanced before the High Court. Had it been there, possibly the outcome would have been otherwise. And I am just completing this paragraph, because whether the notification is subsequently amended by abridging the period of exemption. In such event, the amendment would operate prospectively for the unit which has come into operation after the amendment has come. But the abridgment would have no effect on the industries.
No, Mr.
which had
Sahu, this is the 1992 decision, this
My lord.
Mansfield. Whereas
lord.
Jagannath Packers is a 2005 decision.
And this decision of Mansfield refers to paragraph M, the judgment of the Honorable Apex. So based on the principle millers enunciated by Apex Court millers in Purnami Oil Mills, state of Kerala, and state of Gujarat, Bakul Oil Industries, this judgment is rendered. That's I understand, millers. That's only the effect of the judgment in the two Supreme Court judgment along with Mansfield's case and other pleadings. Actually, tribunal has not considered at all. That's right or wrong.
No need for them to consider. Once the Jagannath Packers judgment is there, there's no need to send it back.
So may I pray that let it be argued at least after I have only quoted here. Let the judgment, I will give you the Lordship the judgment.
Your Lordship, internal page 5 of the tribunal.
Instead of pillars, I also agree with Lords. Next week, let it come and I will be giving all the judgment. I Lordship to consider and pass up to the
No, but we've heard it at length already, Mr. Sahu. It's okay. You see, the present revision petitions by the SSC are directed against the. This is a common order in 2 years or separate order?
Common order for both.
Common order dated 12th March 2008, passed by the Orissa Sales Tax Tribunal. In essay numbers 2176 of 2002-203 and 332 of 2004-05. So the aforementioned appeals were filed by the present SSC, petitioner SSC, challenging the orders dated 29th August 2002 and 27th August 2003 3 of the Assistant Commissioner of Sales Tax, dismissing the petitioner's appeals for the assessment years 2001-02 and 2003-04, thereby
Because that period is wrongly mentioned by the learned travel. It should be 99, 2000 and 2000, 2001.
correct for the years 1999-2000
And 2000, 2001.
2000-01.
My lords.
Right.
Because I have checked up, if your lordship will see the first appellate order number, which is mentioned in the tribunal order, your lordship will find the period is wrongly mentioned.
Right. In turn, the assessment orders passed with the sales tax officer under section 12(4) of the Orissa Sales Tax Act 1947 (OST Act) for the aforementioned periods were affirmed.
Your Lordship, maybe Your Lordship, pause, Your Lordship, 99 2000, but the disallowance has been made with effect from 1/8/99 because on 30th July, Your Lordship,
Yes.
withdrawal has been made.
The background
That is in the
facts are that
assessment
the
order.
appellant, the petitioner carries on the business of manufacturing and selling biscuits. Full stop.
Bread also, my lords. This is bread.
It was an SSI unit duly verified by the District Industry Center, Cuttack, and availed of sales tax concessions and exemptions on purchase of raw materials and sale of finished products as per the Industrial Policy Resolution of IPR 1989 paragraph. The sales tax incentives / concessions granted under the IPR 1989 were withdrawn by the government of Orissa with effect from 1st August 1999. Full stop. 1st August, it says.
Your Lordship,
1st August.
Your Lordship.
Yes, 1st August 1999.
Right. Consequently, the STO included the purchase of raw materials and packing materials from 1st August 1999 till 31st August 2000 in the gross turnover and taxable turnover, respectively. Full stop. Sales for the aforementioned period was also included in the taxable turnover by excluding the claim of exemption. Full stop. Paragraph. Mr. Sahu, learned counsel for the petitioner, contends that the tribunal overlooked the judgment of this court in Messrs. Mansfield Industries,
Electronics, my lords. Electronics.
Electronics, versus State of Orissa, judgment dated 1st May 1992 in OGC number 4151 of 1990, where it was held that till the period of exemption is allowed to run as originally intended, the exemption cannot be withdrawn at any anterior point in time by the state government. Full stop. On the other hand, Mr. Mishra pointed out that the withdrawal of notification which was challenged, of similar notification which was challenged in this court, was negatived by it in the case of Messrs. Sri Jagannath Packers versus State of Orissa. Full stop. Agreed by which the SSCs went before the Supreme Court of India with specially petitions. Full stop. Those were rejected by the Supreme Court by its order dated 4th March 2005.
But this petition has not gone, but others have gone.
Yes.
Group of
Balance.
Mr. Mishra accordingly submits that the withdrawal of the exemption, the effect from 1st August 1999, has implicitly been upheld by the Supreme Court of India, and therefore the impugned order of the tribunal calls for no interference. Paragraph. The fact of the matter is that the Supreme Court's decision in Sri Jagannath Packers, which upholds the validity of the notification in terms of which the exemption granted to the petitioners and other similarly placed assessees stood withdrawn from 1st August 1999, was approved. Full stop. Since that is the very issue involved in the present case, there is no scope for the present court, this court to remand the matter to the tribunal for any fresh consideration, as urged by Mr. Sahu. Full stop. In view of the decision in Jagannath Packers, Supra, the decision of this court in Mansfield Electronics, holding that the entire period of exemption should be allowed to run to its completion, cannot stand, paragraph. In that view of the matter, the court finds no reason to interfere with the imputed orders of the tribunal. No substantial question of law arises. The revision petitions are dismissed.
Obliged.
Obliged. Is the 19 also same merits?
Yes. Both are together. No? Right.
Both are together, yes.
Yes.
Weekly list item 20.
May please, my lords. This matter, my lord, relates to an alleged suppression for the period January to March 2000, my lords. The AO, my lord, what he has done, my lord, he estimated the suppression amount to rupees 5,39,000, and he enhanced the turnover to 4 times 21,56,000. I went up in appeal, my lords. In the appellate authority, my lord, he found that the enhancement paid by the AO, my lord, far exceeds even my maximum production capacity as certified by the DIC as a small scale industrial unit. Then he reduced that amount, my lords, to 3 months, taking the particular amount as stipulated by the DIC, divided by 4, and for 3 months, he estimated the price, and he found out that the alleged suppression, according to him, was 2,48,000, but he maintained that 4 times, and he made it to 9,92,000 for the addition. I went up in second appeal, my lords. It was dismissed. My second appeal was dismissed. My humble contention, my lord, is it's a small scale industrial unit.
So what?
And the alleged, I'd only humbly pray, my lord, it was only for 3 months. And the lordship from the conduct, the lordship would appreciate that they are being taken my maximum capacity for a year, divided it into 4, and determined to be my suppression for 3 months.
No, that's fair enough.
So I was only praying, no subject.
It's only a pro rata thing that they.
No, so let this 2,48,000 be maintained.
First appellate authority has taken very liberal approach.
Yes.
Reduced.
What I was humbly praying was subject to my learned friend and subject to what falls from my lords. The total suppression as determined by the first appellate authority is 2,48,000. May I humbly pray to be confined to that, lords, or at least 2 times a lot of that. 2 times would be suffice. In the interest of justice, my lord,
Just because this is all your discussion.
The
discretion
short issue arises for consideration in the present revision petition, which is by the SSC, which is directed against an order dated 19th May 2008 of the Sales Tax Tribunal, Orissa, Tribunal, whereby the
page 31 is the operative.
Appeal being SA number 993 of 2002-03 preferred by the present petitioner was disposed of. No, was dismissed, and the order of the Assistant Commissioner of Sales Tax, packet ACST, dated 28 May 2002, was affirmed. Paragraph. The SSC admittedly is a small-scale unit engaged in the manufacture of steel furniture, fabricated materials, and agricultural implements. Full stop. During the visit by the sales tax authorities to its business premises on 15th July 2000, materials were recovered which showed sales suppression. Full stop. The gross turnover was enhanced by the STO by rupees 2156,000. That is 4 times the alleged suppression. And the tax demand was raised accordingly. Paragraph. When the SSC went before the ACST, a liberal view was taken by noting that the purchase suppression worked out to rupees 248,000 on pro rata basis for a period of 4 months.
3 months.
3 months, is it?
January, February, and March.
That is January to March of
2000.
2000. The enhancement of the GTO was therefore reduced to rupees 992,000, which is 4 times the actual purchase suppression. Paragraph. This court has heard the submissions of Mr. Kara, learned counsel for the SSC, and Mr. Sunil Mishra, learned counsel for the department.
Your Lordship may say on particular facts and circumstances of the case, and
Yeah.
my Lord and Senior may not take it as a ratio
Yeah.
laid down by your Lordship in other cases. Your Lordship.
Given the size of the scale of operations of the petitioner, which is a small scale unit, and with there being no previous instance of any such sales suppression, the court is of the view that the enhancement of the GTO by 2 times the actual purchase suppression would serve the ends of justice. It is ordered accordingly, and the impugn order of the tribunal is accordingly modified.
2 times of the
Your Lordship,
Actually suppression.
your Lordship may kindly observe on these peculiar facts and circumstances.
This
of the
order is
case.
being passed on the peculiar facts and circumstances of the case and has not been intended to be creating a precedent.
Grateful, Your Lordship.
2 times of the amount determined by the ACCT minutes.
Yeah,
That's
2
2
times
lakhs
of the
40.
actual purchase amount as determined by the ACST, that is twice rupees 2,48,000.
Greatly obliged.
Equalist item 21.
Please, I am in the virtual mode. My lord.
Yes.
My lord, in this case, the defect has been pointed out because there is a common order, impugn order is a common order for 4 years. I have filed the separate revision petitions. So the defect has been not the consolidated revision petition not filed, and no good grounds are there because this revision petition involves the substantial question of law. I have framed the question of law. So these 2 defects may kindly be rectified because I have filed for each year. I have filed the separate revision petitions.
Where are the other revision petitions?
One is 528, 531.
Ah,
For each year, I have filed the separate.
okay. What is the tax amount involved?
Tax amount in 4 years, it will be coming around 7
No,
lakhs.
is it 2 years or 4 years?
4 years, madam.
For 4 years, you filed 2 petitions.
No, two has come. Yesterday, one had come and that has been dismissed because the defect has not been rectified.
Same, Your Lordship. Other 2 years, Your Lordship has rejected. In all the years, several defects are there.
Ah,
And the defects have not been removed for all along.
Yesterday, I could find that they had asked for the consolidated petition because I have filed the separate revision petitions for each
no,
year. So-
maybe separate. Each petition has defects, sir. And not
each-
one defect, several defects.
same ground, say the common
No,
consolidated.
three
petition.
defects in 5D, 9 and 10.
5D is the standing council copy notes of the standing
No,
council.
that is six. That is not 5D.
That is, I have solved the copy.
No, he says that is 6 and not
That
5D.
is defect number 6. That is not here.
So, my lord, I'll be praying that 1 week time, maybe I'll remove
No.
all
It's
because
for
there is
more than 13 years now.
substantial
Cannot be
question of,
removed.
because my
Substantial
tax
question of law
has
is
been,
left open, but the court is not inclined to grant more time for removal of defects. Both these revision petitions are dismissed. Yes.
Weekly list item 23.
Item 23, no instruction.
No instructions. Disposed of. Dismissed. Sorry.
Weekly list item 24.
None appears to dismiss.
Weekly list item number 25.
May I please. Question, my lord, in this case, my lord, is whether the sales tax officer can sit and appeal over the certification of the DIC, my lords.
That's covered.
Contrary to this, and
that is
and the
alright.
other part, my lord, the other part, my lord, is what they have held is that decortication is not amounting to manufacture, my lords.
Your Lordship,
Your Lordship.
when that issue has been decided that decortication cannot be manufacturing, Your Lordship, because there is no new material found out, Your Lordship. Then Your Lordship, the DIC manager, DIC has given the certificate so far as the manufacturing, Your Lordship. So that is contrary so far as the process of manufacturing. So the sales tax officer, it is a peculiar case, Your Lordship. Because only for the purpose of manufacturing, Your Lordship, IPR exemption can be granted so far as the raw material and finished product is concerned. When it has been decided that decortication is not a process or is not a manufacturing, is a process of manufacturing. So there is contrary view so far as the manager DIC as well as the sales tax officer. And this is the peculiar case. So that judgment may not be recognized in this case, Your Lordship.
What
Particularly
has
in this
happened,
case.
what my learned friend, my lord, is contending is contrary to the very IPR laws. The word manufactured includes processing. If at all he says it's not manufacturing, at least it will be processing laws. Manufacturing, as per the OST Act, included processing. So far as the Form 1D relatable to IPR 1989, if your lordship would permit me, I'll show the provision, lord. It includes manufacturing / processing. So this IPR 1989 cannot be strictly for manufacturing. If your lordship would kindly take up that yellow book, if you for a moment, my lords, of Mr. Agarwal. So far as the entry is concerned,
What's the tax effect here, Mr. Kar?
my lord, the tax effect, my lord, would be
83,000.
83,000.
83,732.
You want to contest it for that 83,000?
No, what has happened, my lord, if it's contrary to law, my lords, even a rupee matters, my lord, with great respect. My lord. Even a rupee matters, my lord, because it will upset the entire. If your lordship would kindly turn to entry 25, 26F.
Your Lordship, then this case may be kept in board, Your Lordship. I have to argue this matter and I have to take one.
No, your lordship have consistently
Next
held.
week, Your Lordship.
Even
because
this honorable
these all
court,
are different.
my lord, this honorable court were held, my lord, in Jagannath Cotton and Ginning, my lord, whether Ginning will be, my lord, manufacturing or not, my lords. Jagannath Cottons. It traveled to the Supreme Court, my lords. The matter was remanded. If your lordship would appreciate, the first appellate authority accepts my contention, gives me the relief. The state goes up in second appeal, my lords. In second appeal, they say that decortication is not manufactured, and hence you'll not get it, my lords. Your lordship may kindly turn to the first appellate authority's order, my lords.
Anyway, he wants time to prepare.
Much greater.
Your Lordship,
Your
because why I'm taking adjournment, Your Lordship, the tribunal has cognized the orders of the full bench, Your Lordship, several orders of the full bench.
Well, the tribunal,
And I think against those full bench judgments, either dealer or state must have come to this Honorable High Court. So I want to find out the specific, Your Lordship.
your lordship may only turn to page 29, running page 29. I don't mind my learned friend taking time, my lords. I bow down to that. My lords.
Then let's see it at that time. Then you say Mr. Sunil Mishra, learned AC, the department seeks time to prepare the argument. That is request list on. 20th July,
20.
20 July.
Tomorrow also there's a
Okay.
similar case relating to OST, my lord, of the same SSC.
Let's same day, 20th July.
Then
Both
we'll
are
adjourn it tomorrow.
I'll make a mention tomorrow.
Weekly list item 26.
That decision, sorry, that decision may be kept on record.
Yes, yes.
Ah.
All right.
May I please, Your Lordship?
Copy.
It's purely covered matter, my lord.
Mr. Ven-
Charges collected on the way of rent on the meters, whether it is taxable or not. This court has held elaborately discussed and purely covered.
All right. Yes, Mr. Mishra.
Mal,
See, in view of the decision dated 10th April 2019 of this court in STREV number 68 of 2004, bracket Executive Engineer Ganjam North Electrical Division versus State of Orissa. The impugned order of the tribunal is set aside and the revision petition is allowed as paid.
Weekly list item 27.
Delay is what?
item 27, your lordship, 61,797 is the appeal effect and delay is 1 year, 4 months delay is there.
1/8?
1 year, 4 months.
The delay of 1 year, 4 months is not satisfactorily explained. The MC number 104 of 2009 is dismissed. Accordingly, the revision petition is dismissed.
Weekly list item 28.
Item 28 bills. The lordship was pleased to admit the questions bills on 27/10/2019 9. Page bills 14 my lords may kindly see. Out of 3 questions, the lordship have formulated to accept 2 questions. 1 was not accepted. Question number A and B at page 14 my lord. So whether equipment is same as machinery and will be covered under Finance Department notification number so and so dated 22/12/89 with effect from 1/1/90 and notification number 1691 CTS 1 dated 9/1/2002 with effect from 1/3/2002. B. Whether on the facts and circumstances disallowance of claim of deduction under section 5 to AA2 of the Orissa Sales Tax Act for sale of mechanical equipments, that is idler, to HEC against form number 34 is lawful and proper. These are the 2 questions. Third bills are not considered. Now, fact remains what is sold against form 34. Form 34, your lordship, those bills are a claim of deduction purportedly under section 5 to AA2 of the Orissa Sales Tax Act. Whenever in taxable goods are sold to a registered dealer, whereas free of tax, whereas this form 34 is used, that is furnished by the buying dealer to the selling dealer, so that the incidence of tax whereas will shift from the seller to the buyer dealers. But this benefit of shifting of tax from seller to buyer is not available when the goods is notified to be husband tax paid goods by a government notification purportedly under section 8 of the Act. The claim of all the years this was there for this period for which your lordship is concerned, that is 2001 to and for 2001 bills, 72 and 72 STRE bills. Whereas even if goods are being sold on the strength of Form 34 to HEC, which is a Government of India undertaking bills, and Government of India undertaking also bills after receipt of that, purchasing that goods, has sold to NALCO against form number 4 bills, and order of assessment passed by the competent assessing authority in respect of my purchasing dealer. I have also annexed in this STRE application by annexed 5 bills. That I will bring to lordship notice. The tax has been demanded also on my person because of for a different reason. Because he could not furnish form 4 after procuring from NALCO, therefore demand was. Anyway, my humble submission is But precisely running tribunal finding, I am taking also certain page 30 minutes. 30 minutes.
Yes.
I am instead of all, I am taking your worship's attention to 5 lines from the end of the paragraph. The mechanical equipment loss.
Yes. Idler.
The mechanical equipment that is idler, which is nothing but component parts of the machinery, was therefore subject to tax at the first point of sale at the relevant time. Once the goods is held to be subject to tax at the first point of sale, the appellant being the first seller cannot sell the goods against Form 34, and therefore the forum has rights rejected Form 34. This is the finding of the Lordship Tribunal. But in fact, what idler is, I have given to Lordship Pillars today a compendium of papers Pillars along with the judgment of your Lordship. Plus this idler, this is fitted with a pulley, and this is Pillars is a conveyor belt. It's a part of conveyor belt because this conveyor belt helps in movement of goods from across the one place to other place. So that is what precisely. And idler, your Lordship, kindly see for a moment at page Millers, which I have given to your Lordship Millers, page 24 Millers. What is idler? Because to a common man, it may not Millers. These are unusually Millers. Idler means a person Millers who wastes time and does this is not. This is a third one. Yes, a pulley riding loosely on a shaft, pressing against a belt to guide it, or to take up the slack. Also, idler pulley, idler pulley. And next page, we also kindly see a idle wheel. Sorry, an idle wheel is a wheel which serves only to transmit rotation from one shaft to the other in applications where it is undesirable to connect them directly. For example, connecting a motor to the platter of a phonograph or the crankshaft to camshaft gear train of an automobile. What is happening here? There is a motor and gearbox is there, and this idler is not it has no self-propulsion. Whereas force comes from the motor. It is only from the force available from the motor that helps in moving the idle. Idler itself, the word means it is idle. It is static. It doesn't have its own propelling substance that it cannot propel itself. So therefore, my humble submission is there is one judgment also I have given. Of course, I have not given full report. You also kindly page 23. Pullers are not parts of machineries. Pullers are general goods. 80.1 to 80.13. Allahabad High Court has said pullers are not pulleys. Sorry, pulleys are not parts of machinery. So, Millers, what I am humbly submitting now in the test is the Lordship may kindly come down to 2 notifications I have annexed to this compendium. Millers, serial number 1, SRO number 858 of 89. Whether or not this idler, which is an equipment, and admitted by the running tribunal, whether it is there in the notification or not. If it is not Millers, you will also be kindly see page starts from page 1. The notification starts from page 1, and you will also be kindly see serial number machines. Yes, page 6 Millers. Serial number 6 Millers. Machineries including sewing machines and component parts and accessories there. So this is entry. It doesn't speak of equipment. Then Millers, annexure, serial number 2, final notification. This is under section 8 of the Orissa Sales Tax Act, Millers. Notify. And what is component parts? Component parts, this honorable court and also Millers, other high courts have seen Millers, without which machine cannot function. Accessories are only to Millers beautifying the thing to make it more accessible, and spares are substitute of the one that is there in the machine. So nothing fits into the present case which I am on. This is idler Millers, and this is tribunal also refers to as the mechanical they say mechanical equipment. Equipment cannot be same as machinery. That is a humble submission process, and equipment doesn't find place in both the notification of the state government or section 8 Millers. This is
What's the difference between an equipment and machinery? I'm not clear.
Exactly.
No, what is the difference between an equipment? You are trying to distinguish. You're saying equipment is not machinery.
Correct, correct, Vilas. Correct, Vilas.
What is the difference? I'm not able to understand. What is the difference between equipment and machinery?
It's equipment in this machinery equipment. Machinery and is different than equipment. Machinery, the little I understand, your Lordship has also delivered one judgment in Jaipur Subha's case. That machinery is self-propellant. There must be force from within, and unable to have a little more search to find out some judgment. But the notification, if your Lordship will go through Section 8 notification, that doesn't cover equipment. Yes. That says only machinery. And even the ordinary.
Unless it's
layman.
different, it will be included. Unless
Sorry.
you're able to show equipment is different from machinery, which I doubt.
Machinery parts, component parts, all are there. So you'll see machinery parts, spare parts, component parts, and accessories there. So it is equipment, mechanical equipment is itself a machinery.
Machinery is different. Machinery is completely different than
So
equipment.
why it is a
Plus, let me put a little more
So
effort
all along
to satisfy you.
it is first
I
time
myself, from your side, I have nothing to show more on equipment, except that notification doesn't cover equipment. And to a layman also, mirrors to me also, I feel machinery, equipment cannot be one and same. Because terminologically also, etymologically, equipment different, machine different. So we cannot substitute one to the other.
one and same. Let's see.
No, these are synonymous.
Layman can say one and same. Only
Layman cannot say one and same. This cannot be synonymous. We always use machinery, equipment is different. Machinery, equipment cannot be substituted one for the other. Certainly not, because with great respect, cannot be. It requires little bit more search. Neither the learned tribunal nor anyone.
And also in another entry in that first point tax paid, spare parts, pump sets, generators, and other machinery not specified elsewhere in this notification. Also, that is another entry is there. So you let's see all along it is first point tax paid goods, and it has been admitted that
Never, it is never.
the
Because department has been accepting.
form number 34 is not applicable.
Department has been accepting sale against Form 34 all along, except for these 2 years, my lords. And Annexure 5, your lordship will see for a moment. I have annexed the assessment order passed in respect of HEC, which is the Government of India undertaking, at page 32 and 33, page, my lords. Page 32. This turnover, very turnover, my lords, has already been taxed in the hands of the buying dealer, my lords. And your lordship judgment, which I have annexed in highway trading very recently, your lordship have delivered one judgment at page 11 to 18. It's a very recent judgment your lordship have given. That same transaction cannot be taxed twice. You can't tax in the hands of the buyer, seller. No, that is what. Even on section 8 and section 5, your lordship have very nicely given one paragraph, the appreciation of the relevant provision, saying that the purport of section 5 is rate of tax. It doesn't indicate the point of taxation, which section 8 refers to. So therefore, you can't levy tax referring to the taxable entry when the section 8 itself notifies certain points. And here, so far as the 2 notifications which I have annexed before lordship, that doesn't indicate equipment. That doesn't indicate. And your lordship in paragraph 15, 13, page 15, paragraph 13. So also, para 13 and 15, your lordship have said that it was 18. Para 18 is the most relevant. Further explained that should not be an unjust enrichment part of state, and that would not be proper to tax a person twice in respect of the same transaction, particularly when he has paid tax on a bona fide. The Ramarao case also you have lordship have referred to. So my humble submission is there is no prejudice to revenue cost in this case, lords. In either way, if your lordship will go either way, lords. First of all, this is not reflected in the list of pillars first point tax paid goods, which is to be specifically mentioned in the list. It is not there. Secondly, lords, equipment is different than plant. Even as such, lords, I have given the meaning of the one idler, lords. I have some photograph also that I will share with my lords, lords. And thirdly, even otherwise, my buying dealer has already been taxed in respect to very same transaction because of his failure to furnish pump work. And this deduction, which I have claimed under section 522, 5A2 millers, that says that if the goods are sold against Form 34, That's the only thing I have to ensure that the buying dealer has to put the goods in a course that is subject to tax. That's all. Because subsequently, what you will done that cannot be the domain of the selling dealer. But I have to ensure that the person to whom I have sold mirrors, he has put it in the course of resale. That is what he has done in this case. So therefore, the owner suggests, so far as I am concerned, he has purchased the goods from 34. He has resold this to Nalco, it is Pumpo, which will be emerging from annexure 5 mirrors, the order of assessment of SEC, which the government of India are taking. There is no prejudice in any manner caused to Virat's revenue. So my humble submission is, other than that, I mean throwing more light on the expression equipment. So if your lordship permits me, I can do that also. Otherwise, your lordship may accept my
Reserve
contents.
orders reserved, it will be open to the parties to submit a note of arguments.
Much obliged. Much obliged. Deeply
May I
obliged.
just read what is the difference, my lord? As
Equipment
per
and-
Google, my lords.
Let them do their research.
So they say machinery is a collection of machines and that operate together in order to accomplish a single task. A machine is an appliance that is used to manufacture something in order to fulfill the orders. Equipment refers to the tools that are used while performing the task in order to complete it. So it's an auxiliary to machines.
No, but equipment by itself can be a machine too.
Well, they say, my lord, computer is an equipment.
So why would computer not be a machine?
But machine, but the hard disk is a machine.
Well, it's a way of
Well,
looking at it.
My lord in senior's case has gone because that idea is particularly equipment and
No,
that
I'm not concerned. I'm not concerned whether the case is decided for or against a party, but there is a difference between machine and equipment.
That is exactly. Exactly. And that is not there in the notification. That is my humble submission.
Or orders reserved.
Fine.
Both
Okay.
cases.
Weekly list item 30.
None appears dismissed on orders.
Weekly list item number 31. Item number 31.
None appears dismissed on orders.
Weekly list item 32.
It will become infructuous.
That is
Disposed of.
Weekly list item 33.
Your Lordships, on behalf of Mr. Karunakar Janan, the matter has become infructuous.
Or constitutional petitioner states that the matter is construction. Dismissed as such.
Weekly list item 34.
35 minute time. Here is not second order application, but to the contrary, as earlier stay has been granted in my favor.
You have to speak in the mic, so we can't hear you.
It is second round of litigation. Earlier, this court has protected me. I am filing the rejoinder affidavit in response to the counterfeit filed by state.
let's see this issue. I have received just now. I have received the copy of rejoinder. This issue has already been decided by Jindal. It is
Let me complete it. It is my guess, sir.
again.
I am not placing so far as the appeal payment of 20%. I am not placing. Here is a case, my lord, that without any finding of sale and purchase, basing on the statement of a person, my assessment was made. Before your lordship directed me that to confronted the person concerned who was alleged that he has sold to me. And the said person has confronted Sir 92 of the OVAC Act. In someone he was present, and in the statement I have enclosed, he said he has never sold to me. And I also, my case is from the vigilance that I never purchased anything from him. He said, my lord, that he even didn't know me. And he is also a registered dealer before in the Maharashtra and the state of Orissa. Even assuming, Lord, that there is any sort of
This is assessment order.
Assessment order and appealable.
Your Lordship, please.
And confrontation has been made. Everything has been made pursuant to your lordship.
Constitutional petition seeks leave to withdraw this petition with liberty to avail the remedy of appeal available to the petitioner in accordance with law. The interim order, if the appeal is filed not later than 16th August 2022, accompanied by an application for continuation of delay explaining the delay on account of the pendency of the present petition, which shall be considered on its merits in accordance with law by the appellate authority. The court clarifies it has not expressed any view in the matter. Further, subject to the petitioner filing the appeal within the time stipulated, the interim order passed by this court on 4th August 2015 will continue till such time the appellate authority takes up the application for interim relief to be filed by the petitioner. The petition is disposed of in the above terms.
Let annexure 1 may be written.
Annexure 1 be returned to the petitioner, subject to being substituted by attested photocopy thereof.
Let's see, the same petition, that is the VAT Act. Entry tax is pending if your lordship dispose in same term, 6023 of 11.
Then we say writ petition civil 6023 of 2012.
11, it is 11.
How can that be 11, this be 12?
Sorry, my lord, sorry. Sorry, my lord. 602312.
2012.
That is under the entry tax.
Or-
Same issue.
Yeah. In view of the order passed today by this court in writ petition civil 6022 of 2012, the present petition is also disposed of is withdrawn with liberty to the petitioner to file an appeal in terms of on the same terms as specified in the above order of this court.
Annexure 1 may be written.
Annexure 1 be returned to the petitioner subject to it being substituted by attested photocopy thereof.
Oh, bless.
Weekly list item 35.
Item 35, my lord. In this application, the petitioner was an applicant. We are for the year 2011 and 12.
You have to speak louder, sir.
Petitioner was an applicant for the financial year 2011 and 12. Though the proposal was submitted in favor of the petitioner, the application was not considered by the government.
It's all infractions, sir.
Yes, ma'am, I know that in infrastructure, but what remains to be decided in the during pendence of the writ application, the collector of Puri has issued a letter which I have filed in an additional affidavit in flag AM, my lord.
What is the issue, sir? Left
For
to be decided.
refund of the application fee to the petitioner.
No, refund of the application fee is not permissible because you have applied, that was examined.
Yeah,
it
yeah.
has been rejected by the-
Not rejected, my lord. Not been considered by the government, my lord. Therefore, the collector of Puri has issued the letter to the Excise Commission of Orissa for refund of the application.
What is the application fee?
Let him apply before the excise commission.
What is the application fee?
Application of rupees 30,000, my lord.
30,000.
All right. You see, due to passage of time, the petition has been rendered infructuous. As regards refund of the application fee, it will be open to the petitioner to approach the authorities in accordance with it. The petition is disposed of.
Weekly list item 36.
May it please your lordship, I'm appearing on behalf of Mr. Debashish Panda, who has been engaged in this matter, your lord.
Which item, please?
Item 36, my lords.
What's the item number? I mean, what's the petition number?
WPC number 16689 of 2012, my lords.
All right, because the name doesn't appear anyway. Yes.
Yes, my lord. My lords, the matter has become infructuous, my lords.
All right. Counsel petitioner states the petition has been rendered infructuous. Dismissed as such. All right.
Oblige, your lordship.
Weekly list item 37.
There's no instructions in this.
Yeah. Counsel petitioner states he has no instructions. Dismissed.
I'm appearing on the opposite.
All
All
right.
3.
All right.
Weekly list item 38.
None appears. Dismissed. Non-constitutional.
Weekly list item 39.
None appears. Dismissed. Non-constitutional.
Appearance of interview noted, my lord.
All right.
Weekly list item 40.
May I please, sir? So this is a case regarding change of nomenclature of the petitioners. In this case, there is an interim order, and the defect is notice has not been received by the OP5. My lord, so OP5 is not functioning till now. This may be deleted, my lord. And no counter has been filed by the state.
As I appear on behalf of the state, as the counter has not been filed in the writ petition, but if my lords will take up the contempt, there is a contempt application as well. There, my lords, we have made it clear that the issue pertains to, my lords, recruitment of certain ATOs who are assistant technical officers on a contractual level. And Millards, in our reply to the contempt application, we have made it clear that that particular post, Millards, has to be advertised by the Orissa State Selection Board, and it cannot, Millards, be the principal of the ITI institute cannot, Millards, appoint. And if that appointment has been made, that is only for a stopgap arrangement, and it cannot be a permanent appointment, and it's a contractual appointment. That is, Millards, the sum and substance of the case. So therefore, Millards, although the counter affidavit to the main petition has not been filed, from the contempt application, at least it's clear that there is no contempt, because they said that in the meantime there was a change in the nomenclature and they were appointed as Millards guest lecturers and paid on hourly basis, which is exactly what Millards, the principal of the ITI institute, is authorized to do, because otherwise it's an advertised post. The ATO post is an advertised post.
Let them to file the counter,
Why should you? He's prepared to argue without a counter. We don't need a counter. It's a 2013 matter.
And Millards may see the writ petition, page number 9, Millards, which is the contract which was entered into between the petitioners and the institute. Millards may kindly see the clauses. Millards has page 9. It's annexure 1 of the petition.
Yes. Page 13.
Page.
Anyway,
Yes, it starts from 9 because there are a couple of all the petitioners, all of their contracts, the similar contracts. So page 13, Millards, clause Millards 6. The contractual ATO has no right or claim for regular appointment to any regular post. Thereafter, Millards, clause number 2, the contract engagement can be terminated at any time without assigning any reason. So clearly, Millards, there is no claim that the contractual ATO can do for a permanent post. And in fact, Millards, the principal ITI is not authorized because this is an advertised post and there is a procedure by the Orissa State Selection Board. And if and there is another petition, Millards, which had come before another bench, which is WPC 22267 of 2012. Which also pertains to advertisement of certain posts.
Where is it pending before?
This was before Justice B.R. Sarangi and Ms. Savitri Rath. This had come on 8th of April 2022. So Millards, there might be certain overlaps. I haven't seen that file. So
let the opposite party to file the counter, Millards.
Sir, they don't want to file counter. Why are you asking us to compel them to file counter?
This notice has been issued and
so what? You argue the matter.
Let the matter listed next week, Millards.
Why?
Because conducting advocate is not.
You can't wait for so long to ask for adjournment, sir.
Next week,
no,
maybe listed.
Tell us what is your answer to this very small point. Your prayer is about change of nomenclature of your posts. They're saying that they're agreed by the name of the post being changed.
Initially appointment was given as ATO, assistant training officer, contractual, but subsequently part-time guest instructor.
Doesn't make it any better, sir. It is not permanent. It's only contractual.
The contractual, we have completed more than 6 years, my lord. Accordingly, our service to be regularized by the state. Unless the
by an interim order of 2013, you've been continuing.
Yes.
For nearly 10 years now.
Millards, that then again is hit by Uma Devi, which says that any continuation under any
interim
order of the court you cannot claim 10 years. So therefore, Millards, they are hit by Uma Devi as well.
Now he's saying.
My lord, the interim order was not for continuance, my lord, only to payment the salary. Our continuance is not with the order of the honorable court. Only order was that to pay the salary.
So you are not continuing now?
Yes, my lord, we are continuing.
Then you're continuing because of the interim order.
There's a prayer. If my lord sees the prayer is in effect, my lords, they are altering the agreement which they have signed to. And then, my lords, if it's a advertised post by a particular constitutional body, then obviously, my lords, they cannot have the principal Balesor cannot appoint them. And if they have appointed them and they are getting hourly wage as opposed to a monthly wage. And the contract clearly says that they have no claim for regular appointment to any regular post.
Why was there a contempt petition filed?
Well, the contempt was filed because in the meantime, there was a order passed where it said that if the petitioners are working as contractual ATOs, they shall be paid their salaries or wages as admissible regularly. As thereafter, my lords, the principal Balesor ITI has changed the nomenclature and they are getting hourly wages. To which the stand of the state is that the principal ITI is not authorized. The authority lies somewhere else to appoint even contractual ATOs. So therefore, there is no contempt on the face of it. And as the agreement terms are very clear, my lords, that they are bound by it and they don't say otherwise.
By the time they filed this petition, how long had they been working?
Well, they were appointed, my lords,
in 2007.
2007, my lords.
Working
And my
for about
lords,
6 years.
if my lords turns to page 24 of this petition, my lords, it is from the Additional Secretary to the Government to the Commissioner cum Director, Technical Education and Training. I am directed to invite a reference to notification so and so on the above subject and to say that the General Administration Department have included the post of Assistant Training Officer in the Schedule 1 of the Orissa Staff Selection Commission Rules 1993. The said post is included in the said schedule in serial number 27, the Employment and Technical Education and Training Department in column 3, my lords. So therefore, my lords, and it is their document, my lords. So therefore, my lords, once it is included, my lords, under the Orissa Staff Selection Commission rules, only the Orissa Staff Selection Commission can make appointments to these particular posts, for which, my lord, there has to be an advertisement and thereafter. So they cannot claim any preferential rights, my lords, to get appointed as ATO, even contractual, because that is exactly what, my lords, this document says.
I think the only thing we'll say is amounts paid pursuant to the interim order shall not be recovered. This should not be that they were not regular pay and therefore differential amount should not start getting recovered. So the date is under an interim order. We'll have to see that. That will not be asked. petition is dismissed, the contempt petition is disposed of. Already disposed
There's a
of.
contempt. Contempt may be disposed of.
No, he says it's already disposed of.
Weekly list item 41.
You are my lord, infructuous, my lord.
Counsel the petitioner says the petition has been rendered infructuous. Disposed of.
Opposite party number 8.
Weekly list item 42.
Item 42, my lordship, I am myself Subhajit Satpathy, appearing on behalf of Mr. B.K. Naik. My lord, as per his instructions, the petitioners were contracted to draft the rejoinder, but it could not be done. So kindly grant 3 weeks time to file the rejoinder.
We are not. Proceed with the matter, please.
My lord, this is a case of illegal settlement of land in lease, case number 125 of 1988/291 of 1988. And it is a government Abada Jogya Anabadi land. The villagers of the land, they have built a Shiva temple and a pond, which is used by the women ladies of the village. And the opposite party number 5 had filed an application for settlement of the 8.8 decibel as a green holder card holder. And the villagers have filed an objection on 17/5/1994. And the Tahsildar, ignoring such objections, have settled the land in the favor of opposite party number 5.
So there is a statutory remedy for all these things.
Yes.
Why writ petition?
Yes, that is it. And add to it, this is already allotted to the beneficiary since 1988. And after so many years, not at all. She was a green card holder, and there was a policy of the government that will allot some land, and accordingly. Now they say that it is for their own purpose. They want that this lease should be cancelled. And if they so desire, they can challenge the lease in appeal. And in the meantime, your lordship will see 24 years already passed.
But my lord, opposite party number 5 tried to take the position. The villagers filed an application to the collector on 8/7. I think that still they do not have the position till now.
That I cannot say whether she is in possession, but as per the law, she ought to have been put to possession because once they leave. He is saying that that is not in possession, but we are not on that. Your lordship is to examine that whether the impugned order can be challenged or whether any interference can be made. Whether she is in possession or not, that is her lookout.
Correct.
Whether you have got any locus standi to challenge the impugned order of settlement.
My lordship, the husband of the petitioner of opposite party number 5 is having Gauravali land in his name. It can be seen in the annexure 4.
That is, as a green card holder, the lady is given some land. You are saying something that she is not eligible. That eligibility criteria we have examined, and if you so want, then you can challenge it in appeal. But once it is already allotted to a party, for last 24
It
years.
is seen that the challenge in the present petition by 14 petitioners who claim to be residents of village /PO Antia, police station Jenapur, district Jashpur, is to an order dated 1st September 1994, passed by the Who's passed that order? By the Tahsildar, Dharmasala,
Dharamsala village.
In the district of Jajpur.
In lease case number 125 of 1988, /291, 125, 1988. 88. Settling the land at measuring AC 0.08 decimals in favor of opposite party number 5. Stop. On the face of it, it is seen that the challenge has been raised nearly 20 years after the settlement of the land. Stop. While directing notice to issue in the petition on 19/12/2013, this court had directed status quo to be maintained by the parties. Paragraph. It is seen that the impugned order is an appealable one under the Orissa Government Land Settlement
OGLS Act.
OGLS Act.
Under the Government Land
1962.
Settlement Act.
1962.
And therefore there was no occasion for this court to entertain the present writ petition in the face of the availability of the statutory remedy. Stop. Consequently, the court, while not inclined to interfere in the present petition, permits the petitioners to avail of the statutory remedy available to them in accordance with law. The interim order is vacated. The petition is dismissed.
Weekly list item 43.
None appears dismissed.
Weekly list item 44.
44, no instruction, my lord. No instructions dismissed.
Weekly list item 45.
Order number 2.
No, 46.
The TIL was filed. Oh, yeah. Regarding some high-rise buildings being raised along the seashore at Puri. However, it is seen that in the last 8 years, no progress has been made in the present petition and no replies have been filed by any of the opposite parties. So, considering that there are other petitions pending in the court on similar issues, the court is not inclined to pass any further orders in the present petition, and it's disposed of as such.
Weekly item 46.
This is infructuous, that is excise matter already.
Yeah, the subject matter of the present, considering the subject matter of the present petition, it is obviously become infructuous since there are other orders passed by the Supreme Court concerning the said issue. The petition is accordingly disposed of.
Weekly list item 47.
47, my lord, infructuous.
Consular petitioner says the petition.
No instruction, your lordship may say no instruction.
That he has no instructions, the petition is disposed of.
Weekly list item 48.
My lord, no instruction, my lord.
No instructions, dismissed.
Weekly list item 49.
I'm for the OCM, I was appearing for Orissa Cricket Association earlier, my lords.
All right, and appears to the petitioner, dismissed for non-prosecution.
Weekly list for orders item 50.
I'm appearing for opposite party too.
All right, and appears to the petitioner, dismissed and non-prosecution.
Supplementary list. Fresh admission item number 1.
Lords, this is a PIL I have preferred on behalf of 15 such children who are suffering from one rare genetic disease called Dutch.
You're in person.
I'm in person.
So anyway, you're not supposed to wear the gown, but it's okay. Anyway.
Apologize. Lords, I'm preferring this present PIL on behalf of 15 such children who are suffering from Dutch.
He's made a detailed representation. Did you see that? What are your instructions on that representation? Where is it?
I have to obtain instruction.
All right, Mr. Mudali, the additional government advocate, states that he will seek instructions on the petitioner's representation dated 4th March 2022, made to the Department of Health and Family Welfare, Government of Orissa, on provision of treatment through antisense oligonucleotide bracket AON bracket therapy
Right.
to 15 children stated to be suffering from the Duchenne muscular dystrophy bracket DMD. List on 11 July. 11 July.
Supplementary list for orders, item number 2.
I may be permitted to the rate petition, my lord, in pursuance to Annexure A of my miscase, my lord. They have already issued a fresh notice on 148AB, and that's why I want to order it, because I have already filed a return in pursuant to that notice before
All right. The petitioner seeks leave to withdraw the present petition.
I may be permitted, Lord, says, Lord, I want to take instruction in this matter because this, Lord, IA has been filed based on the Lordship series annexure attached to the miscase. That is a case, Lord, yes, order has already been passed. And this
he simply wants to withdraw, he says.
No, he's withdrawing. He's withdrawing because he's stating that the basing on the judgment of the Supreme Court, this notice is issued. But that is a mistake. That it is a earlier notice 140 issued prior.
It's up to him. If he wants to withdraw, how can you prevent him from withdrawing a petition?
I'm ordering
It's for him to withdraw and do whatever he wants.
Before the ITO Khordha.
Counsel for the petitioner seeks leave to withdraw this petition with liberty to seek other appropriate remedies as may be available to the petitioner in accordance with law. Disposed of is withdrawn with liberty is paid for.
Annexure 213 became redundant when?
It's all right. Yes.
Supplementary list, item number 3.
May I please, Lord? Lord, this is a public interest litigation, my lord.
What is this defect not removed?
Lord, all other defects have been removed. Only defect remains that is regarding the margin.
You remove it, sir. List after removal of defects.
Lord, I may be permitted then to file a fresh because the margin I have to replace.
All right. Counsel the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition in accordance with law. Disposed of is withdrawn with liberty is paid for.
All right. Supplementary list, item 4.
Item 1, I could not follow, my lord. That's why. Is it PIL? Item 1, I could not follow, my lord. That's why.
No, a detailed representation has been made to the government. So we've asked the government to find out what the present position of that representation is.
Oblige, my lord. Oblige. Sorry, man.
Supplementary list, item number 4.
My lord, item 4, my lord, here after the judgment of the Honorable Apex Court, the matter 148 issued after April, 1st April 2021.
So you can withdraw this now?
Yes, my lord. I will be liberty to take appropriate action.
Yeah, yes, same order as in that Mr. Patnaik's matter. 4 will be the same as 2. Right.
Obligement.
Supplementary list, item 5.
May I please, I mean, granted some time to remove the defect.
All right. List after removal of defects. All right.
Supplementary list, item number 6.
May it please your lordship. And petitioners are a group of villagers of a village named Kendumunda village. They are seeking a direction to the opposite parties for execution of the work order for construction of a Anganwadi center. So, my lord, the guidelines for construction of a...
You made a representation.
I have made a detailed representation to the collector, sub-collector, as well as the block development officer.
All right. You see the petitioner's representations. Dated 8th April 2022. Shall be examined by the collector, is it?
My lord.
Collector then canal, and after giving the petitioners an opportunity being heard, a reasoned order should be passed thereon. Not later than 5th September 2022.
My lord, the difficulty is actually the Anganwadi centers, these Anganwadi centers, the construction has to be completed within a period of 1 year. There are guidelines, my lord, that is that.
And appropriate action be taken on that basis. Okay.
Obligement.
The petition is disposed of. Court has expressed no view in the matter.
Supplementary list, item number 7. Supplementary list, item number 7.
Pass over.
Supplementary list, item number 8.
My lord, in this item, I request for a passover, my lord.
The 8, there was a direction, if your lordship looks at the last order.
Eight.
The petitioner is to obtain instruction with regard to the OEA proceedings.
Correct. But he's asking for a passover.
Yes, my lord.
All right. Pass.
Supplementary list item number 9.
But 9 actually, if your lordship looks at the amendment application is filed at flag T. This is actually regarding the grant of production certificate which has been granted by virtue of the order of this honorable court. After the grant of production certificate, we have to file it before the authorities for granting the incentive certificate with regard to IPR benefit. We have already applied before the authorities. That's still pending. So originally when the application was filed, it was not available, that it was not incorporated. Now, since all these things have developed in the meantime, we have filed this amendment application to incorporate the same and to take your lordship for consideration. Now, that amendment application flag T, that was objected by opposite parties 3 and 4, that is at flag U. Then paragraph 7, if your lordship looks at the objection, 13, I think. They say if it is allowed, they should be granted opportunity to counter it.
Yeah. That they will obviously. So without prejudice to the rights and conditions of the parties.
Absolutely correct.
So this is miscase number
12591 of 21.
Milord, I have objection to the amendment. Kindly hear me, Milord.
Yes, please.
I am appearing for the Energy Department, State Government of Orissa, opposite part number 2 and 3.
Yes.
As a special counsel.
Yes.
Milord, kindly bear. Milord, this writ application was filed in the year 2006.
Yes.
And the prayer in the writ application was completely different. It was a prayer, Milord, to stay the certificate proceeding before the collector Jagatsinghpur till disposal of a writ petition already pending before your lordships, which was filed by them for production certificate.
Yes.
That production certificate has been issued, and on the very same day, kindly look to the order dated 22nd March 2007. It will be clear to your lordships. There, your lordships specifically directed 22nd March 2007. Well, I am reading that order. Miscase number so and so is filed for vacation of the interim order. That was filed by me. Dated 19/4/2006, passed in miscase number so and so. Today we have disposed of WPC number 11531 of 2003. This is the writ petition, directing the state government to take a decision in respect of grant of production certificate. Therefore, we direct that in case the petitioner deposits a sum of rupees 2 crores with opposite part number 3 on or before 31st March 2007 and further a sum of rupees 3 crores within next 2 months. This meaning thereby 31st May 2007, the proceedings in certificate case number 2 of 2005 pending before the court of certificate officer cum collector Jagatsinghpur shall remain stayed. The above deposit shall be subject to further orders in this court passed in the instant and writ petition. Milord, here what happened? Milord, pursuant to this order, he only deposited first 2 crores. Did not deposit the balance 3 crores within time. This order has not been modified. And kindly at this juncture, your lordship may look to the prayer portion of the original writ application. Prayer portion. What was the prayer? It completely changes the nature and character. He may file a fresh writ application. I am nothing to say, but kindly see the prayer portion, Miller. Here the prayer is, Miller, to pay dues as raised by the opposite party number 3. Miller, our dues are around 20 crores, 28 odd crores. That is the electricity duty, which he was not paying. And balance that 2 crores which has been deposited, it remains as 18 crores and odd with interest to be paid. As raised by the opposite party number 3, and further be pleased to stay further proceedings of the certificate case number 2 of 2005 pending before the collector come certificate officer Jagatsinghpur till disposal of the writ application. This writ application was disposed of on 22nd March 2007. So this writ became infructuous. There is no stay continuing. So now in the meantime, he says he has obtained a production certificate. He now prays for incentive certificate. But here there was no prayer for incentive certificate. This completely changes the nature and character of the litigation, Miller. And this amendment is filed after 15 years. Your Lordship knows, in this case, originally Mr. Ashok Parija was appearing. He became the Advocate General. He cannot file a matter against the government. So therefore, Mr. Misra has been engaged. So after engagement, he thought that without amendment, there is nothing in the writ petition. So after 15 years, and if a Lordship will look at the amendment, it is more than 3 times of the writ petition. Kindly see.
Actually, the main prayer itself was subject to the outcome of the other writ petition, which has already got
If your
disposed of.
Lordship looks at paragraph 13 of the writ application. But the relief has to flow from the pleading of the parties, Mother.
Whatever.
If Lordship looks at paragraph 13.
No, one of the reliefs is for you to get an incentive certificate.
Yes, Mother.
But that is not your prayer.
It was not available at the relevant time.
I know, but
we had in fact.
But way back in 2006 or 7 itself.
Yes, 2007 actually.
At that stage, the amendment should have been moved, if at all.
But here actually, Lordship, 2 things are there. But IPR says I should get the benefit for 5 years. But 5-year benefits, the period of demand is for 5 years, that within that period. We have informed them by filing an application that, look here, since my application for incentive is pending, therefore this demand is not viable as such. The reason being, I have been given the IPR benefit with regard to the sales tax benefit on the basis of the same production certificate. Same production certificate is to be considered by the Director of Industries. So Director of Industries has kept the matter pending. Now that is the reason why I have to amend the writ application, that once you have granted the production certificate, I'm entitled to the benefit. I should also be entitled to one benefit has been given. The other benefit is obvious. So there is no question of stopping my benefit.
No, but why wait for 14 years to...
So actually what has happened, that company has been transferred in the meantime. IFCO has taken over. But the original company's liability remains. So therefore I have also filed the amendment application to change the cost item.
If you get your incentive, it will not cover 20 crores of dues.
No, the due is not 20 crores, Millard. But due is 1 crore 84 lakhs amount. They are calculating with regard to the interest. The period for which actually it was claimed, I have already deposited 3 crores.
No, my Lord friend is confusing, Millard. Kindly see the counter affidavit filed by me.
Only thing here is that, Millard, if I get the benefit, no demand will be outstanding.
How you get the benefit?
It will be exonerated.
Millard, kindly
my 3 crores are lying with them.
Millard, the allegation is he has installed 2 generating
it is only my own generation.
One kindly allow me to say. 2 generating stations, one is diesel, another is turbo, that is thermal, without permission of the authority. And under the Odisha Electricity Duty Act, they are to submit a monthly return before the authority stating how much they have generated and what tax is payable. And to evade this tax, Millard, they never obtained any permission. Without permission, they have installed it. So therefore, the date of commercial production is not known. If the date of commercial production is known, they will be entitled for exemption for 5 years. That is a different thing in merit. But now we are on the amendment petition, Millard. Now question is, there is mirror as I showed the order dated 22nd of March. The stay has become, whole writ has become infructuous.
Sir, kindly see page 26, my lord. With due respect, my lord. Kindly see page 26, the amendment application, my lord. Form E 96.
Yes.
It says date from which it has gone into commercial production is 16/4/2000.
That is according to you.
No, my lord. This is a director of industries. Says the
Yeah, but
director
maybe-
is a certificate that has been granted. If your lordship kindly see page annexure 10, certified of eligibility for sales tax concession on raw material, machinery, spare parts, packing material, finished product under IPR 96 as a new unit. That themselves have granted is
No, this is in 2007.
2007.
Ah.
On the basis of which I made an application for incentive of IPR 96 for the power merit. Power sector, if your lordship looks at IPR.
Your production certificate and incentive certificates are two different things. In the first writ petition, there was no prayer,
Only
no
after
word
getting the
regarding
production
incentive.
certificate, the date of commercial production will be known. If
So
that
that
is
he-
known, then IPR benefit will be granted. If that
there
is
is a
not
fresh
known, it
cause
will
of
not be granted.
action, if there
Once
is a
it is
fresh
known to
cause of
them,
action, my
they should have
grant
themselves
friend may
granted.
file another writ.
So kindly have a look at clause 8.5 minute of the IPR minute. I've given copies to your lordship minute, IPR copies. I had given that earlier minute. 2 copies, kindly see minute. Clause 8.5. They have themselves acted on it on one part. The other part they have kept.
No, but the thing is, you waited for 14 years to move this amendment.
No, reason the matter was kept pending actually from then.
No, this pending was not necessary to be kept pending at all. because
No,
the prayer had become infructuous.
I'm not that issue that is pending or not. But the question arises, but immediately after it was brought to an notice, I filed it. Kind of see clause 8.5.
Because even this certificate of the DIC was issued in 2007.
That was issued on the immediately. Kindly see the 2 letters, my lord. Yes, my lord. If you also kindly see the bona fide, kindly look at the letter dated 19/5/2007, page 20. Page 20, my lord.
Yes.
You know, say rightly indicated. Page 20, my lord. Kindly see.
Yes.
Annexure 7, 19/5/2007.
No, but there are seem to be other complications of setting up your own self-generating plants without a permission.
So kindly look at the next letter, Annexure 8, page 8 June 2007.
No, Mr. Mishra, it's not so straightforward as it seems. I think we'll have to file a separate writ petition.
Well, same thing, my lord. If you are to avoid the multiplicity of proceeding, my lord, but if can be decided here, at least there is no difficulty. The reason
No,
we
the
give
non-grant of incentive for power seems to be a separate issue altogether.
That it completely
Not so,
changes
it's not
the-
automatic that you got the production certificate, now you should get the
Second,
incentive
one
certificate.
one thing I would like to bring your lordship notice, my lord.
Yes.
So kindly see Annexure 8, my lord, page 22.
See, they may have conditionalities saying that unless you clear yourself of all those other penalties,
Sir,
they're not
it's a-
bound to grant you an incentive for power.
No, sir, it is a letter issued to the chief engineer, electrical inspector, my lord.
Yes.
Kindly see page 22, my lord.
Yes.
It is the director of industries who writes a letter.
That's right.
Inviting reference to the subject cited above. I am to inform you that Oswald Chemical and Fertilizer has installed 2 into 55 megawatt capacity captive generation plant, applied for recommendation for ED exemption, but the date of commissioning of the said sets has not been indicated in the initial inspection report, which was issued by you.
By your
at
office.
2000 in favor of plant. In view of that, you are requested to intimate the date of commissioning the above sets so that the recommendation can be made in favor of the unit. They kept it pending. Next letter, 12/6/2007. Again, a letter has been written by the electrical inspector to the
filed a
data
writ
company.
petition soon after all these correspondence.
It is their own letter, my lord.
No. This is 2007. All of this is happening in 2007.
Yes, my lord. Right.
And you don't do anything for 14 years.
No, thereafter, actually, kindly see 2007, the benefit was given so far the sales tax is concerned. All these are records available on record.
No. But the delay has to be explained too. 14 years, how can we be sleeping on this? You say this petition was filed originally.
And if you also kindly hear me for 1 second on it, but that REIT application which was pending at the relevant time, in that REIT application, in spite of the prayer it was available, the Honorable Court directed to deposit, and I deposited. At that time also the prayer was available. That was not objected. 2 REIT applications same day listed. One disposed of with a direction to grant the production certificate. And the other REIT application, it was kept pending, but it could have been made infructuous at the same day itself.
So we don't know what prevented that from happening. You must have said, don't dispose it off.
The reason being the production certificate was to be granted and I can file it in the other REIT application.
That's right. All right. You say the okay, you start like this. See, the present petitioner filed 2 writ petitions in this court. No, that was a 2003 petition, please.
That was 2003.
Yeah.
But this was 23/3/2007.
No, disposal. But the number of the petition is the petition's number is 2003.
No, page 4 of the amendment application, I have quoted those things. Kindly have a look at that, man. It was not disposed of, it was kept pending.
No. My thing is,
that is WPC.
You had filed 2 writ petitions, 11531 of 2003.
2003. Your Lordship is right.
2003.
Yes. And 1833 of 2004. You had filed 2 writ petitions.
2 writ applications. One order I have quoted in page 4. That was disposed of with the direction to grant the production certificate.
All right. You put down this writ petition 3278 of 2006 along with this case IA number, along with IA number 12591 of 2021. The challenge in the present petition, which was filed way back on 1st March 2006, was to the action of the chief engineer, project chief electrical inspector, generation, powerhouse, unit 5, Bhubaneswar, in raising a demand with regard to payment of electricity dues. Electricity duty, is it?
Duty.
Electricity duty, ED, on self-generation and consumption by the petitioner. Full stop. A further challenge for the petitioner was to the initiation of certificate proceedings in connection with the said demand under certificate case number 2 of 2005, pending before the certificate officer collector Jagat Singhpur, opposite party number 4. Paragraph. Even while the said petition was filed, the petitioner had already filed 2 other petitions, namely writ petition civil number 11531 of 2003 and 1833 of 2004. The aforementioned writ
If
petitions.
your
were
lordship
with res-
permits my lord, file fresh writ application, then I can file a fresh writ petition challenging the entire thing, my lord.
But let us at least note that the main prayer has become infructuous then.
The main prayer was actually till the disposal of
That other writ petition,
Right.
that's over. The main prayer in the present writ petition was that till the disposal of writ petition civil 11531 of 2003,
Yes.
further proceedings in the aforementioned certificate case number 2 of 2005 should remain stayed. Full stop. The prayer in writ petition civil 11531 of 2003 was for a direction to the state government to issue a single quotes production certificate unquote to the petitioner in terms of the industrial policies resolution
Right.
of 1992
96.
of 1996 bracket IPR-96 bracket. As it transpires, when the present writ petition was heard along with the aforementioned writ petition on 22/3/2007, an order was passed in the connected writ petition for grant of production certificate for this order was passed directing the state government in the connected writ petition to take a decision in respect of the grant of production certificate to the petitioner. Full stop. The court is informed that since then a production certificate has in fact been granted to the petitioner in April 2007.
Yes.
Full stop. Paragraph. On 22nd March 2007, on the same date that the aforementioned order was passed, the following order was passed in the present petition. Reproduce the whole order. Paragraph. It is seen, therefore, that on the aforementioned date itself, the main prayer in the present petition had been granted, and therefore, I think survived as far as the present petition is concerned. Paragraph. However, in view of certain developments that took place soon after the grant of production certificate, involving the petitioner's plea for grant of bracket single quotes incentive certificate, the petitioner decided to file the present amendment application, IA number 12591 of 2021, seeking to incorporate certain prayers in that regard. Paragraph. The said amendment application has been vehemently opposed by opposite parties 3 and 4 for pointing out that it is far beyond the scope of the main petition. Stop. Mr. Panigrahi, Learned Senior Counsel appearing on their behalf, urges that the petitioner cannot seek to amend the present petition since the amendment seeks to expand the scope far beyond the original prayer in the writ petition. Paragraph. Mr. S.P. Mishra, Learned Senior Counsel for the petitioner at this juncture, states that the petitioner would like to reserve its liberty to file a fresh petition in regard to the prayers made in the amendment application.
Right.
So, in that view of the matter, both the main writ petition as well as the amendment petition are disposed of with liberty to the petitioner to seek other appropriate remedies as regards the prayers made in the amendment application.
All right.
My lord, with regard to that 20 crore spending, your lordship may clarify there is no interim order continuing.
Yeah. The interim orders have worked themselves out, and the court clarifies it has not expressed any view on the merits of the contentions as far as the amendment application is concerned. Yes.
Supplementary list item number 10.
Only item number 10, my lord passed an order on 30th March 2022 at paragraph 5 of the said order. My lord instructed me to do the needful. And with regard to that, my lord directed me that the exercises should be taken up between 18th and 28th April 2022. On those 4 days, we called for the persons concerned. And in fact, we have prepared a report and I have brought it for kind consideration of this report. But however, it is not for the court. It has not been final because of the reason that they have given us some of the PF cards. We have not with regard to PF cards, we have to go to the PF department because of the holidays. We could not do it. But however, we have already shortlisted the 46 names of 46 persons, and they are with regard to the documents. We have verified that, and with regard to the date of birth, like that, and only 46 persons in terms of the minor's order. They have not so far attained the age of superannuation. But this chart is not final because of the reason that we have to verify with the PF authorities. For that reason, I require 4 days time, and in the matter, I will give you the complete report to your lordship. So far, we have come here.
See, Mr.
In this, all the documents we have verified, and it is put on a. In this,
My lord, in this case, my lord, submitted. They have given 4 days, but they have not given 4 days. They have given 2 days.
No,
only 18 and 22. They have given 2 days. And in
sorry,
yes, my lord. I mean, in 2 days they have given 18 and 22. But because of other day, they have not allowed us because of your lordship direction, and your lordship may kindly take para 5 clause 1, my lord. 18 and 22, because of that 18 and 22, they have allowed only
between.
My lord.
Shall present themselves between, you've said.
Yes, well, from 18 to 18, 4 days.
No, they have not given my lord. I am there. I personally there. My clients are there. They have given only 18th and 22. And on 18th and 22, I have signed their signature.
In that event, let me submit. On 16th, this Mr. Singh went to our the main gate with 50 persons, and they closed our gates. I did not allow our employees to enter into the premises, saying that the High Court has passed the order directing for reinstatement.
No.
This person, he himself.
No. I'm sorry.
Went there.
I personally.
And he has given us a letter also.
No, I have given.
And he is now saying that we are not allowed.
No. You are allowed.
Sorry,
No, you are allowed. You are allowed. Only 18 and 22. I am saying that they have allowed. My clients are gone, verified the documents. All facilities are given by the company. Everything is there. I am not disputing that part. I am saying that before my lord, 18 and 22, they have given 2 days. So other people are there. They could not attend before the opposite party to verify all the documents.
So you should have filed an application here, or you should have asked for directions. If anyone was being prevented from going, you should have asked for directions.
No, my lord. No one, my lord. No one, my lord. I am there. No one, my lord. No one prevented.
There are more people. No. Yeah, if there were more than 40 people willing to go back.
If there were more than 46 people.
Yes,
and they
more
were
than
prevented only on 2 dates they were allowed.
No,
Why
no
application was not moved before this court?
No one prevented me, my lord. No one prevented.
There are more than 46, and you say that only on 2 dates they were allowed.
They are allowed only 18.
So why application was not moved before this court?
I have not allowed because I have not filed an application, but they have allowed only 18 and 22, my lord. I am saying.
No. Do you have? We are not clear what you are trying to say, sir.
It should be.
No. Are there persons beyond 46 who are willing to go back?
My lord, let me submit.
More than 46, my lord, my seniors, some that they have more than 46 are gone, but they have selected 46, but more than about 60 to 70
actually
people.
61 persons came, and out of the 61 persons, 20 persons already attained the age of superannuation. So they were not considered.
Anyone is left behind?
Yes, ma'am.
Apart from 46.
No, but in that event,
another 20% are there.
No. Have they attained superannuation or not attained superannuation?
Not attaining superannuation, but they are living outside of Orissa. They are some Andhra Pradesh, some Karnataka, some
Then
Rajasthan.
if they don't come, what can one do, sir? We can't wait endlessly.
Because due to the non-communication, they could not come and attend on.
No, no, which is they? Give us names. You have the names.
I'll give you in course.
You're all taking your own sweet time, sir. In fact, the day this 22nd April got over, we are now in June.
My lord.
What were you doing for 2 months?
I'll get to. I have already prepared. I have already prepared. I could not file because of.
No, there's no names. There's no chart. We don't know their age. Nothing.
Yes,
and you don't file an IA. You do nothing.
Well,
how are we supposed to do? Pass an order.
I have prepared. I will submit today, my lord, because it is not final. I will submit in by OIFA affidavit. I have prepared, my lord. I have prepared. I will by OIFA affidavit today. I will file because
Mr. Saragi says that in terms of he said 61 of the workmen had approached the management pursuant to the order passed by this court on 30th March 2022. According to him, of the said 61 persons, 20.
My lord. See,
15 must be.
61 minus 40.
15 minus 15 is 46. Around 15 persons had already attained the age of superannuation. He has prepared a chart of the remaining 46 persons who had all given their particulars, including the PF slips, pay slips, appointment letter, and so on. And which 46 persons still have some years of service left. He needs some more time to verify their PF details from the PF office. Paragraph. Counsel appearing for the workmen, on the other hand, insists that there are certain other persons who are outside of Orissa who could not reach in time to appear before the management on the dates stipulated by this court, that is between 18th and 22nd April 2022. He states that he will file an affidavit providing the details of such persons. If those details are provided to Mr. Sarangi, then it comes to the management not later than 27th June 2021, 2022, then he will further verify those details along with the details of the 46 persons and prepare the final chart not later than 10th August 2022. List on 17th August.
Supplementary list item number 11. Item number 11.
None appears to system non-prosecution.
Supplementary list item number 12.
This matter was taken up on the last occasion because this is an order passed by Micro, Small, Medium Enterprise Development Act. There, the Board of Secondary Education was directed to pay a sum of rupees 10,000 and odd, along with compound interest. I have pointed out that there was a civil suit also pending. My learned friend pointed out on the other day in the counter, saying that the suit itself was disposed of and dismissed. So your lordships have suggested him to take instructions if this party will be agreeable to take the principal amount and without interest. That he is to tell the instructions to.
In the counter, my lord, there is I have already stated counter till 2015. There is a 7 lakh something is my lord, because as per the statute of the Micro, Small, Medium Enterprise Development Act, section 16, the interest has been calculated. Now it will be more than 10 lakhs also, my lord. So this is a 24 years, my lord. I have to hindering here and there and 10,000 rupees. And after 24 years, my lord, that will be the amount very small, my lord. Because so far as merit of the cases, my lord, they have not deposited the statutory deposit. That is the act, the statute, my lord, section 19 of the Small Scale Act, that is Micro, Small and Medium Enterprise Development Act, section 19, my lord. So if they will challenge the award, they will deposit 75%. That is mandatory, my lord. They have not deposited that money. And so that's why the lead petition is not maintainable, my lord. That is section 19, my lord, under the act. Micro, Small, Medium Enterprises Development Act 2006. That is special statutes for the small scale industries, my lord. They are for only to prevent their exploitation from the authorities. So that's why this act has been come into force in 2006. And the award has been passed under section 18. The statutory body, under the act of section 18, the statutory body has been constituted. And they have passed the award with the capacity of as arbitrator, my lord. That is section 18 of the act. They have passed the order and the award. And section 16 as they have already clarified. That is section 16, may I read, madam? Where any buyer fails to make payment of the amount to the supplier as required under section 15.
See, you have to be realistic.
Madam?
You have to be realistic. You want him to go for separate proceedings for this 10,575. You've already waited for how many years?
No, madam, the award was passed in my favor.
Correct. So how many years have you waited?
They approved this annual.
Sir, how many years have you waited for that?
24 years.
You want to wait for some more years, looks like. You're not in any hurry to get your money. What you're suggesting is let him go file something else, somewhere else. I'm prepared to wait, you're saying. He's prepared to pay you something. You say, no, I don't want any money. Let him go. Don't have him in writ petition. Let him go in other proceedings. Is this what you're advising your client? You have waited for 24 years. Let us wait for 10 more years.
So down that regard, madam, only the principal.
He adjourned it only for you, thinking that you will be giving some advice which is practical and reasonable to your client. But you seem to advise your client, let us keep fighting. 24 years is not much of a time. Let us fight for 10 more years.
That's why
that seems to be the attitude.
My sir, that's the amount must be reasonable. That's why my submission.
You should come forward with a proposal that is reasonable then. You come forward with a proposal, then we can put it to Mr. Rao. If you say, no, forget, I have waited for 24 years, I'm happy to wait for 10 more years, then we will record that you're willing to wait for 10 more years.
That's why, my lord. No, the situation, my lord, now as per the act statute, they will pay, that will outstanding more than 10 lakhs. So the lordship may decide, man, because that is reasonable.
We'll simply decide the petition. Then you will not make any statement, you will not make any offer, you will say nothing. We'll decide on merits. No, I'm asking you. You want us to decide on merits then?
No, that on this regard, my lord, I will take instruction because
the whole adjournment was only for that, sir.
10,000 was only, my lord.
For 10,000 rupees, if you want to fight for another 20 years, if that is the advice you want to give your client, we cannot stop you because you have studied the act so thoroughly. You've gone through every comma, full stop in the act, and you're telling your client, we'll only go by the act, we'll only go by litigation. We will not bring this to an end now.
My lord, may I submit, my lord? That is not the 10,000 exactly, my lord. The award is principal amount was 10,000 because our claim. But as per section 16, if the interest will be calculated, that will be 7 lakh at that time. The award is at that time itself 7 lakh.
All right.
That's why my submission. So, because the award.
So which means you want to argue only on merits.
Nothing.
You do not want to climb down even 2 inches.
I want my money.
Fine. So with this, it took you 24 years. You have come 24 years.
I have not come, my lord. We have approved.
Very good. So what have you got? Nothing. Till date, you have got nothing. So what is the attitude you want to see? The whole idea of trying to have mediation and other alternate proceedings is that if you want to bring the petition to a close, then there's something that you have to be prepared to give up. But from whatever you've argued so far, you're saying, I do not want to give up even this much. I want to get every penny that I want to get under the act. I want to get that. That seems to be your attitude, correct?
No, no, man, not
No.
exactly, not exactly.
See, we
This
adjourned
is
it for instructions only for that. If you're saying, sir, my instructions are we should get every inch of every penny that we are entitled to under the act, then we will decide it on merits.
Next date, I will take instruction on what is the exactly amount plant.
You have to make a proposal, send it to Mr. Rao. It's not that we adjourned it by 2 months, then on that day you will come and say, this is the amount. Then Mr. Rao will say, I take instructions.
I will give intimation.
That is, see, basic approach is this. Do you want to bring this litigation to an end or you don't want to bring it to an end? That is up to you.
End it. Because they have come for the litigation. I have not approved.
No. If they have come, they will keep going, sir. They will not stop here. You should learn to anticipate. You should give a practical advice to your client if you want to bring the litigation to an end. Suppose you are telling the client, sir, let us fight tooth and nail. We will somehow get every paisa that we are entitled to, then that will take its own time. It will take its own course. So if you are willing to give up something, then you put a proposal right away. Don't wait till the next date of hearing. That's what we are trying to tell you. You say, Mr. Sujeshwar Mohanty, learned counsel appearing for the opposite parties, seeks some more time to come forth with the proposal, which he will, without prejudice to the rights and contentions of the opposite parties, communicate to Mr. Rao, learned counsel of the petitioners, to enable Mr. Rao to take instructions. So how long, sir?
1 week.
1 week. That's on. 6th July. Mr. Rao, you also have to be practical and reasonable. Right. All right.
This matter related to mandaps, and last occasion, your lordship directed that it is accordingly clarified that this court's order dated 19th November 2016 will be strictly followed by all concerned till such time the new regulations are framed. To that effect, CMC filed an affidavit on 3rd August 2021 that the firm is to engage a firm of Bombay for primary regulation. An agreement was executed with CRISIL of Bombay on 3rd August 2021. The firm is expected to submit the draft regulation within 5 months, which would thereafter be placed before the state government for approval. Now almost a year is completed. No steps have been taken with the agreement executed by the CRISL. And that apart, one more submission, as per the 9/11/2016 is concerned, I have also issued a letter to the CMC as well as the DCP regarding the violation of the order. So kindly see the para N of the 9/11/2016 order. It is stated, Mandap owner shall inform the local police station, ACB traffic, Cuttack, dates of booking of function. Then para O, a squad will be formed under the supervision of the ACB traffic, Cuttack, to visit mandaps, banquet halls as per the information supplied by the mandap owners as stated above, to ensure that there is no parking on public roads. In case of violation, fine may be imposed against the owner of the mandaps, banquet halls at the rate of 10,000 for first instance and ₹20,000 for subsequent instance, and the fine amount may be shared between TMC and CMC. TMC is the Traffic Management Committee. I was also a member of the Traffic Management Committee, and as far as my knowledge is concerned, since 4 years, no fine has been imposed. Since 2017-18, they have collected some fine.
To find out. Instead of writing to them saying, you better tell me how many people have been violating, you should find out who is violating and tell them.
Sir, as a personal capacity, I could have
Something
been
has to have young lawyers go on.
as per lordship's
If
order.
you write like this to them, they will say nobody's violating.
No.
You know what they will say.
As per your lordship's order, a squad will be formed by the ACP traffic. So they regulate whether on the public road on the date of the functions, a parking or not. To that effect, I have also wrote a letter to them, but as far as my knowledge is concerned.
May I say one thing? With your lordship stand for me. His own brother's mandap is running in Baluwajar without a parking. It is being allowed with license. We are having parking facility of 100 vehicles. We have been denied license.
Whose own brother?
One of my senior, my friend, Mr.
I am-
Vidya's brother. His own brother is running a mandap, Lakshmi mandap in Baluwajar, the most busiest area of Cuttack town.
I am not favoring that my brother, what my brother do. I am not favoring, I am not concerning about any individual capacity. In on respect, I am, if any mandaps
And he
do
is
any.
interested in this case.
Mr. Bhudia, then why should you be involved in this case at all?
No, if your lordship, that lordship did.
Yeah, why have any embarrassment to you or your brother?
No, if any favor is given that mandaps, then matter would have been something different. If your lordship, I will not maybe continue, but.
Let him see whether 5 vehicles can be parked in his mandap. 5 vehicles can be parked in mandap. Any fine imposed on me, my lord, I'll accept. Because I'm of that area, I know it personally. That's why I'm saying, my lord.
That is correct.
But there is no such allegation to that effect, regarding traffic jam and all that. Nothing has been done. License, his mandap will run. My mandap is in CDA, in sector 11. My mandap will not run. And it is closed for last 4 years. No, your lordship, order is clear. Last order, if your lordship looks at, that order says that as per the previous guideline that has been issued, and now they are granting us the permission to run mandaps in different areas with limited resources. Whatever they have permission has been granted. Only thing they are not granting is trading fees is they are taking, but trading license is not been granted. They should grant trading license and nobody violates. So far as my clients are concerned.
May I suggest
Yes.
two things. One is that those draft regulations for the core Cuttack area, because of the confined space that we have here, those will take some more time because they're being discussed now. After discussion, they will be published for public comments and then they'll be finalized. So
There's some timeline. Like you're saying, it's already a year now. This has been going on for so long.
My instructions are to request for 4 months more, my lord.
4 months? No question. You finish it within a month or 2 maximum.
2 months, at least 1 month, they'll not be able to do. I'll come back to my lord and
solve
again.
the entire problem.
Yeah.
If the regulation will be.
They should inspect individual mandap, madam. They should allow that this much only people you can give. Well, let the mandap run, or else, madam, it is not possible for every citizen to have any function or get together in their house. Because your lordship has been there in this.
No, even if in the house there will again
There
there
will
will be
parking
parking
problem.
Parking is always going to be a problem.
It is always a problem
Parking is
because
always-
everybody.
Even on the ring road,
Yes.
just getting into that Pramod or whatever. and
Yes,
coming out,
yes, my lord. Yes.
It's very difficult.
Pramod.
This is a typical town, my lord. If your lordship knows that
And
lanes and bike are there.
Such lanes are there, my lord. Even 2 bicycles cannot run at the same time. There are such lanes.
And we are accustomed with that.
And they
All
should
Cuttack people.
formulate- They have been dragging this, municipality has been dragging this for so many years that they are not formulating, they are doing indiscriminate, they are doing discrimination, madam. A person who runs a mandap
Local people actually,
in Calcutta town, he will be allowed.
local people adjust amongst themselves to have functions. Because somewhere actually, if you also find in Cuttack, roads are closed, and the local people accept. And the function is being held in the road.
In fact, for the parking for that 1-day match, T20 match,
Yes.
they cleared out that whole riverbed. One portion of the riverbed was used for the parking.
Yes.
That is a temporary.
That's a temporary thing.
See,
Let
Mr.
the same arrangement continue till they do it within 3 or 4 months.
No, 2 months. Mr. Devshis Nayak states that the process of preparing detailed regulations is taking some more time. And the Cuttack Municipal Corporation expects that the exercise will be completed within a period of 2 months from today. So the court directs that the regulations prepared, these will have to be prepared.
And government has to approve it. That is the only thing. It will be sent to
prepared
the
and
government
placed
and
before the
government
government for its approval,
cabinet approval is required.
not later than. 5th September, 2 whole months you're getting 5th September 2022.
Within that period, we have to send it to the government for approval?
No, by 5th September, you send it to the government.
My lord.
In the meanwhile, the directions issued by this court on 9th November 2016 as reiterated in the order dated 8th February 2022 will continue.
8/2/22.
Yeah, 8/2/2022.
February.
Yeah. Paragraph. Mr. Budhia Learned, amicus curiae states that in view of the fact that a close relation of his is also running a Kalyan Mandap,
His brother.
he would like to withdraw.
But I have no authority to issue license or to close the mandaps. But my learned friend stated, that is correct. I want to withdraw, there is no problem to that effect. But what my learned stated allegation, I have no authority to continue the run of my brothers, which is totally separate.
Correct.
I have 5 brothers. But his allegation is that 5 years,
And
since
with
4 years.
avoiding any embarrassment, he would like to withdraw
My lord.
as amicus curiae. Mr. Budhia's request is accepted. Just as amicus curiae. So we'll list it on 12th September.
Yes.
12th September.
12th
September.
All right. My one prayer, my lord, I have no authority to issue license or to close the mandap. My learned friend stated.
That
should be there, my lord. Then I have no authority to close the mandap or to continue the mandap.
All right. All right.
And you allegation is that I am, I 4 years, I am not allow him to continue. That is his submission, my lord.
It's all right.
Then
shadow. My lord, for the state, along with me, Mr. Eswar Mahanti, ASC.
Right, right. Please make it. Yeah, obviously. All right.
Supplementary list item number 14.
14 months.
May I please your lordship your lordship may kindly have a glance to the last order where your lordship directed the
Yes, my lord. 10/5/2022. The affidavit, my lord, just what they did.
affidavit to file an affidavit.
Filing. Copy, my lord. Copy, I'm just giving. In fact, regarding the affidavit which I filed, my lords, I want to see that due to some cases pending, that annexure D by 5 and 7, page 7. Clear that block education officer is written to
The breach has not yet been completed.
Not
here.
yet completed because of the reason.
It
my
has
lords.
been admitted.
Yes, yes.
But the fact is that the students of these blocks, my lord, they are unable to, my lord, reach out the higher education because of the natural barrier, Rusikulya River. And they want that the Kesara village, which is situated within the vicinity of 3 kilometers, as per the scheme, it can be upgraded and so that they can have the education. Because the girl child, they cannot go, there are dropouts after, my lord, standard 8, my lord, 7. And the Kesara fulfilling all the criteria.
In fact, the council.
And the proposed upgradation of the Rangavali school, which is far away from the, my lord, these schools, my lord, around 8-9 kilometers.
No, 5.
And they say that within 1 kilometer, they are having the high school, which is opposite side of the river.
No, 1 minute. The para 7 is very vague, Mr. Parida.
Para 7 months. So.
Yes. What does all this mean? Progress substantially, completed shortly.
37% has been completed. What has happened, my lords? Kindly.
No, some timeline has been.
Timeline, my lords, problem is 2 times they have filed the writ petition before my lords. Because of that, my lords, already we have resigned that agency's order twice. So first time, again, he approached my lords, then to consider his show cause. Then again, we give an opportunity to that agency. Then again, he did the same old thing, my lords, and giving all baseless show cause note, this reply, my lords. And again, second time also, we're going to resign, my lords. That's what, and page 7 and 8, my lords. Superintendent engineer was written to the BO, my lords. It means that because of the cases, my lords, and this case also has been disposed of.
However, the London High Court was at all convinced is baseless argument by the agency. Instead, the Honorable High Court directed the agency to submit the reply to show cause notice. Again, he gave a show cause notice reply, which was not to any substance matters. For that reason, matters, we are also going to resign that order and give it to another agency matters. For that only that delay is there, matters. Only 37, that is 37% of the work has been completed.
That's
And in
hardly
fact-
anything, sir.
And in fact, matters, by London's friend submission, there is a counter affidavit dated by the opposite part number 2. That is on 11/12/2018. My lord has already also directed to take instruction whether that has been upgraded or not. This school has been upgraded and 2 batches have already passed from the school. And
No.
this
So
Kesra High School.
Kesra High School.
Yes, Kesra High School. Kesra High School, my lords. There's another paragraph 8 that is clear. It's pertinent to mention that there is already one recognized high school within the vicinity of 5 kilometers from village Kesara known as Ramachandra Vidyapit, Singhpur, and the said high school is already in receipt of GIA from the government. As such, the students of the petitioner's village, that is village Kesara, are not required to cross the natural barrier in order to reach Ramachandra Vidyapit, Singhpur. That is in the same side, my lords.
My lord, we
By
are,
road
my lord,
or to presently upgraded school Ramachandra, which is at a distance of 3 kilometers from village Kesara. And
my lord,
they
Kesra,
are
it
also
is
studying
not-
there, my lord, within the same side. Not, they need not have to cross the barrier. There is already existing high school and they are also going to that school.
Here the
And this is the
people of
second school.
Kesra is not asking. My lord.
Yes, yes, this is the second
Learned
school.
Senior
which
is
is-
misunderstood.
No, no.
Kesara, people of Kesara village is not asking for upgradation. The other villagers are asking to have a upgradation in Kesara so that we can, our children can study there. Because Kesara is having all the facility. It is up to standard 8, it can be upgraded. So that we can within 2-3
Why are we not
kilometers,
upgrading
we can read, our children
That's
can read
exactly
there.
what is it in the counter, the additional counter.
Not that
Another-
Kesara.
Not Kesara. There is another high school where students are going. That
That is-
within the same side.
No,
They don't
that
have to
is-
cross
that
the.
is
There's a need for one more upgraded high school. Why don't you give, if there's a need, why don't we upgrade?
No, that's why we upgraded this other school matters, which is which has objected Rangavali. We have already upgraded and 2 batches have already passed from that school.
No, nobody's objecting to your Rangabali or Ramachandra or whatever.
Yes.
He's saying as far as Kesara is concerned, why don't you upgrade the school also? What is preventing you from
No,
doing
that is,
that?
and counter also that the land is not sufficient for that matters. We don't have that much of land to as per prescribed norms. The land is not available on the Kesara. That's also a
My lord,
reason.
so
why-
far as the Rangavali is concerned, there was no land. It is the report. My lord,
Yes,
may
yes,
kindly see.
they have acquired, man.
There was no, rather the.
No, but is it true there's no land available?
Yes.
No, my lord, so far as the land is available, the Kesara school is existing over the government land.
No, that they need more land. If you have to upgrade, you need more land. That's what he's saying.
So far, it is to, this instruction is to be given by the government because there are.
No,
land.
he's the one saying there's no land.
My lord, land is there, my lord. Land is there, my lord.
Where is land?
My lord, so far as the, my lord, Kesara is concerned, there are land, my lord. Lands
He's
are-
saying there isn't. So you shall point out where the land is.
So I have to take instruction on that.
Mr. Parida states instructions that the government is not in a position to upgrade the school at Kesara beyond 8th class since sufficient land as per the prescribed norms for such upgradation is not available. Mr. Raut states that he would like to seek instructions on this specific aspect. Right in the beginning, you say a counter affidavit has been filed by the School and Mass Education Cell. Inter alia stating that only 37% of the bridge work is complete and that there's a pending writ petition.
No, writ petition has been disposed of, second one. And where my lords have directed that to consider the show cause again. The reply. And that's what the annexure is.
No, the second writ petition says 13055.
1305.
Instead, the High Court has directed the agency to supply the reply to the said notice.
So it should notice issued by this office, means notice issued by us.
No, the 13055 is over.
Yes, Manoj. That's why he has said that the agency has once again submitted next paragraph, Manoj. Submitted the office the same basis old argument. That's he has given a reply.
And that action has been taken to
again resigned, Manoj. Deciding to.
rescind the contract issued to the current agency and to engage another agency to complete the work of construction of the bridge at the earliest. List on. September. All right.
Supplementary list item number 15.
May it please your lordship. My lord, this is a PIL for a direction to the state government to install nucleic acid amplification testing method for detection of HIV, HCV, and HBV infections in the blood, which is received from the donors in the blood bank. Now, my lord, when a donor donates a blood in the blood bank, it has to undergo certain testing for detection of HIV virus and other types of viruses. Now, a test known as ELISA test is being used, but the window period for that test is 90 days. Suppose yesterday a person contacts HIV virus and he donates the blood in the next 1 week. So that ELISA test will not detect that HIV. That blood will get transfused to another person. So this NAT system, which has been introduced in 6 blood banks out of 55 blood banks, this can detect it within 7 days. And my lord, I would like your lordship to turn to page 14, information under RTI Act. After introduction of this test, 434 units of blood, which were otherwise detected negative in ELISA test, they have been found positive. So 434 units would have been transfused to certain persons and it would have led to spread of HIV virus. And the state government has accepted in the counter that we will be doing it in a phase-wise manner, but till date, my lord, it remains at 6. Only 6 blood banks have it.
Yes, Mr. Mudli.
This counter update was filed in the year 2018, where we have stated that in 6 blood banks that NAT facilities have been available. And in the meantime, more than 3 years, I have to file the
Mr. Mudli states that he'll file a supplementary affidavit explaining whether the system of testing of blood samples in the various blood banks has been upgraded and made more efficient so that the possibility of infected blood of donors being received can be detected at the earliest. List on. The affidavit will be filed before the next date. List on 23rd August.
Supplementary list item number 16.
Item number 16, my lord. Lordship, Mr. Pitambar Acharya instruction in the matter to appear, but he has some personal difficulty, my lord, so I pray for a short adjournment.
All right, Mr. Acharya stated to be in some personal difficulty. 25th August.
Supplementary list item 17.
17, madam, not pressed, madam.
Counsel petitioner states that he's not pressing these petitions.
Two matters are there, madam.
Yeah. Dismissed is not pressed.
Supplementary list item 18.
Lordship, item 18, I am appearing 2 matters, first 2 matters, Lordship. In fact, there is a judicial order to list this matter on 29th, but there is a miscase, Lordship. I have made a prayer to inflate the GA department party, Lordship. If Lordship, that will be done, that it will be taken on 29th. On merits also, I am ready, Lordship.
IA 3734 of 22, for the reason stated, the application is allowed. And then this 3740, same thing.
Lordship, same.
Both these applications are allowed, and the GA department is included as an opposite party. The amended memo of parties be filed within 3 days. List on 29th.
29th, Lordship.
Copy may be served on.
Copy, I'll serve copy on G department.
State, because earlier state was not a party item.
That's why I meant party. State, school and already counter is there. They filed counter. I have extra copy.
Supplementary list item 19.
Item 19, I have received the Parawai's comments. I have to file the counter affidavit, so I pray a little adjournment.
Your Lordship, I am appearing on behalf of the petitioner, Your Lordship. Your Lordship, in this, the sole counsel has joined.
Yes, he has also joined
last week in the government panel, Your Lordship. So I need to file a fresh. Yes, Your Lordship. So I need to file a fresh wakalatnama, Your Lordship.
All right.
In the
the request
meanwhile,
of, simply say the request of counsel for the parties. 14th September. Counter deposit will be filed within 8 weeks and rejoined up of the next day.
15th September.
Supplementary list item 20.
Item 20, my lord, we have filed the counter affidavit on 13/6. I'm filing the hard copy. I'll also serve a copy on my learned friend.
Let a copy of the counter be served.
All right. Rejoined to be filed for the next date. List on 14th September.
Supplementary list item 21.
May it please your lordship, I'm appearing on behalf of Mr. Debashish Panda, your lordship. Your lordship is on his legs. Can I pray for a Passover? Item 21 and item 24.
All right.
Oblige your lordship.
Supplementary item 22.
May I please your lordship, 22 and 23 Passover. My senior is just coming. My
All
lord.
right.
Supplementary item 25.
Yes, please.
Sir, even Galileo's testament, sir, to prove our heliocentric solar system, cost his life as sentenced by the Pope. Now, I am not like Galileo, nor am I a professional lawyer, sir. But what is, sir, justice must be seen to be done. Sir, both my IA filed in 2018 and 2021 to allow me for participating in the recruitment process for 2018 and 2021, which are the following recruitment process of 2015 has been declined by you, sir.
Your lordship, can see paragraph 7.
And
recruitment process has
subsequently,
been
sir, the
completed.
2022, I didn't file any IA. It is because there is no vacancy in physics in this year advertisement. Sir, now you think, sir, when one of my co-applicant is able to appear for the recruitment process 3 times by now, and even more to come, leaving me only 1 time throughout life period. Is it my fault to born at such a time, my lord? So therefore, I request you, please allow me to consider the previous petition, original petitions, and I mean 2757 of 2017, from which this today's petition 190306 has arisen. And I have mentioned that in the cause title of this present petition, and in also in clause 9 of page 8 of this 190306 of 2018 petitions. So actually,
in fact, there
I
are
have
2
submitted a
advertisements.
memo,
Pursuant
sir,
to the
also.
past advertisement of the year 2015, only he was not selected. And so far as second selection is concerned, that is of 2018, and that process has been finalized in the meantime, and the selected persons have joined. That we have stated in paragraph 7.
No, sir, in 2015, all the vacancies has not been exhausted. As per the Orissa education rule 1992, if the roll list, the select list is valid for 1 year, and all the vacancies has to be exhausted serially. And
So
in the
one
past
contention, they are pointing out one thing, that only the Orissa education recruitment and conditions of service of teachers and members of the staff of aided education institutions, 1974, only those rules are applicable.
No, sir, when we have filled up the forms, it is Orissa education rules, which I have enclosed in the annexure also.
No, so that fixation of upper age limit rules does not apply. That's what they're saying.
No, sir, when you see the fast recruitment, I have made it. That is why I'm requesting you to consider the, the hearing of both the cases. In the original case, sir, what happens in when the board is formed, in 1990, fast recruitment was conducted. By that time, I was reading +2, and even my teacher was recruited, who has already been retired. The second recruitment process conducted after 25 years in 2015. for which I have appeared. I have qualified also and appeared the interview, but I could not secure in the 50, there is 50 vacancies. I could not secure my position within 50. That is okay. But the rule says that if the 50 seats is not exhausted, then subsequent those who are there, they should have been called, and they have called also. As per they have called also, but all the post has not been exhausted. That is what I want that if you will consider the discussion, I mean hearing of both the cases, the thing will be clear that if.
Which is the other case? What's the repetition number?
Sir, 2757 of 2017.
All right. Say Mr. Mudali has handed over the counter affidavit of opposite party number 2, a copy of which has been handed over to the petitioner who appears in person.
2757 today you will not hear.
It's not here with us.
Probably that is assigned to also single bench.
Oh, that's a single bench matter.
So, sir, then it is actually the real cause, that one, and I have mentioned in the cause list of 1900-306, the present petition, I have made it in the cause list.
No, but here you challenge the virus, so it has come here.
I have made it in the clause 9 of page 8, sir, here also. And that is why I am requesting, sir. Unless you see this one, then allowing this petition doesn't suffix my bread and butter also, sir. So my real problem is with the original petition. Since they didn't listen to the original petition, I applied for a second time. 2018.
No, you make up your mind, sir. If you want to pursue this, it just has to be only before a division bench. If you want to pursue that petition, it's before a single judge.
See, I am throughout my life, I am only eligible for one time. And if you see today's petition also 900-306, as for the amendment 2015, they have made a upper age relaxation amendment 2015. They have amended in 900-306. Sir, since the recruitment process was not there throughout 1990-2015, so how come the 2015 amendment will be applicable? It has to come under 1989. And in 1989, the clause clearly, which I have attached also, 1989 clause 3 here, it is clearly mentioned by any year if the selection could not be conducted, then age relaxation should have given. Sir, accordingly, I have applied a hard copy to this state selection body. I have to consider my offline applications, but it was rejected in 2018, sir. Then 2018, since they didn't listen to me.
All right. So counter affidavit has been filed. That it says this list along with writ petition civil. What's the number?
Sir, 2757 of 2017.
2757 of 2017.
Sir,
on
15 September. Sir, I will tell the 2017 cases.
We are asking that case to be listed with this case.
Sir, today you will not listen.
Sir, that case is not before us, sir. We need the paper of that case.
Sir,
that's before a single judge. So we're listing it for 15 September.
Sir, this court here?
Yes.
Thank you.
Yes. If you want to file a reply to this today's affidavit, you can file a reply.
Sir, this counter they have filed.
So if you want to file a reply to it, you can file.
Maybe within 2-3 days after reading through this.
Yes, yes. You have time. You have time.
Take the phone number and some.
Right.
Thank you, sir.
You call the passover. Supplementary list passed over matter item number 7.
None appears despite a passover. Dismissed for non-prosecution.
Supplementary list passed over matter item number 8.
Your Lordship, on behalf of Dwarika Prasad Mahanti, I'm saying passover. Mr. Mahanti lacks in court number 7.
Is the matter alive still? Is it?
Your Lordship, we are appearing for opposite party 3 and 4. Last occasion, Your Lordship is directed to about the OEA proceeding obtained of
instructions they have to be obtained regarding OEA proceedings.
Despite a passover, Mr. Monty is unavailable. In the interest of justice, lift on 15th September. 15th September.
Oh, bless you. Supplementary list pastor matter item number 21.
Is that same? Both are criminal appeals. Which is yours, sir?
Mine is 22.
You can start, sir.
Item 22.
May I please, your lordship?
Yes, please.
But this is a criminal appeal, my lord.
22 and 23.
Pardon?
22 and 23. There are two.
22 and 23 are not connected, two separate matters.
Oh, I
I'm
see.
ready in 22, my lord. 23 I will adjournment for it. I will pray for an adjournment. Let 22 be.
Okay.
Maybe hard, my lord. 22. Separate matter, not connected.
All right.
But in this case, my lord, the 4 appellants were placed under trial. 2 have been convicted, 2 have been acquitted. And initially, my lord, 6 accused persons were implicated by the informant in the FIR. Your lordship may kindly see the FIR. I have given the English translator copy, my lord. Your lordship may kindly see the FIR. Your lordship will have an idea about the initiation of the case. The vernacular language is there in the paperwork, therefore I have translated in English, my lord, for your lordship's convenience. FIR has been lost, my lord, by one Tapas Kumar Muria, who is the son of the deceased man. The son of the deceased man, this is, I am placing, my lord. Sir, myself, Sri Tapas Kumar Muria, aged about 22 years, son of Surendra Muria, village Sabaka, PS so-and-so, Sadar Katak, today on 19/20/10/98 at about 1 a.m. night meets you near Ghataga Bridge, Khalarda, village Bidanasi, Kakadpur Canal Road, and submits this written report that my father, Sri Surendra Muria, aged about 40 years, had set out from the village at about 8:30 p.m. night on his Luna moped number so-and-so to the house of Yudhishthira Rautran. Here, my lordship will find, for a pause for a moment, here lordship find when the prosecution story is started by initiation of the affair. As per his claim, my lord, with the informant, he said that I meet you, sir, here in this spot. I am lodging this affair. But the police officer, I will point out, my lord, the police officer said, in that night, I have never gone to the spot. And this informant also said that I have not given that information in the spot in the police station. The first inconsistency, thereafter will go, my lord. In Lorna moped motorcycle so-and-so to the house of Yudhishthira Rautran, whose house in Khalarda, near our village, or some household one, at about 12 a.m., one Akshay Pradhan, PW6 mile, who belongs to our village, and one Akshay Mahanti, examined as PW7, who belongs to Baripada, our neighbor, Bisipada, our neighboring village. Both of them came to our house by a motorcycle and informed me that my father, after being assaulted, is lying in this place, dead and denied with blood, and drenched with blood. Myself and my family members, my uncle Dhirendra Muria, PW5 Malari, and Nira Porida, he has been examined as PW2 from the village. Your lordship will find that he had no knowledge, he had not seen, he had from 2 others and lost this affair. Your lordship will place their statement subsequently. When we reached, we saw that my father's face, neck, beneath the ears, the master and the left hand were injured, and he was lying dead. They are drenched with blood. His moped and the slippers that he was wearing were lying near the dead body. I got to know the incident from Akshay Pradhan, PW6 mile of my village, Akshay Mahanti, Bisipada, Sujit Nayak, Rosananda Porida. All of them have been examined in my own. I'll place their evidence from Khalarda and others that about 11 p.m. night to tonight, while my father was returning home from the house of Yudhishthira Raut, not examined. In the aforementioned place, Deepak Kumar Mahanti, my lord, the present appellant number 2, alias Tunna, son of Kailash Chandra Mahanti, Sana Mehendipur, Bijana Porida, my lord, Bijana Porida, alias Tonia, my lord, he is an accused in a split-up case who has been acquitted, my lord. Your Lordship, 4 accused persons were placed under trial in this case. 2 were absconded. There was a split up trial, and in the split up trial, 2 accused persons have been acquitted. And the 4 appellants who were placed under trial in this case, my lord, out of them 2 have been acquitted. Same set of evidence. 4 have been acquitted, 2 have been convicted. I will place my lord. Deepak Kumar Mahanti, Tutu, son of Kailash Chandra Mahanti, Sasana, Vijana Porida, alias Tonia, acquitted, my lord. So and so, and Dibba, son of Duryodhana, Sasan of village so and so, Nochia, son of Nini Sasan, Okhya Swain, son of Noi Swain, of Kolorda, Subhes Rautre, son of Sunakar, Sasana Kolorda, followed my father by the motorcycle from Kolorda bridge in about 10 to 15 minutes. They sped towards Pratapnagari and left the motorcycle there. My father had a prior enmity with them for various reasons, for the same reasons. On finding my father alone in a lonely road, they have killed my father. They have taken away rupees 1,000. And my lord, for this affair, on the basis of this case, my lord, charge was framed against 4 accused persons because 4 were arrested and placed under trial. 2 were absconded men. 4 accused persons were charged under section 302/34 for killing the deceased, and the 404, my lord, for taking away 400 rupees, my lord. Your lords may kindly see, he is the son, my lord. He is none else than the son. Your lords may kindly see his evidence. Pidul 4, my lord. Pidul 4. The son, my lord, the most important and most vital witness because he is the son of the deceased. Your lords may kindly see. I have been convicted on their statement. Pidul 4, Tapas Kumara Mulia. First up, my lord, I have shown your lordship that he said that I see on the spot and lodging this affair. Before that, I want to clarify. Your lordship may kindly turn to page 96 of the paper book. Page 96 of the paper book for a moment. Paragraph 27. I'm sorry, 95. 95. Page 95 of the paper book. Paragraph 27. Your lordship what? Paper book, 95.
Yes, please.
Page 95, my lord, paragraph 27. I had not personally gone to the spot on the midnight of 1920, 1098. The IO said, my lord, I have not gone to the spot. He said, sir, seeing you here in this spot, I'm lodging this affair.
Right.
And in the evidence, he said, no, I have given that affair in the police station.
Right.
And your lordship may kindly see his evidence. This son, my lord, the most important and vital witness in this case, what he has stated, your lordship may kindly see, he has been examined as PW 4. Tapas Kumara Muria, his evidence, your lordship will find at page 53 of the paper. 53. Your lordship may kindly turn to 53 to see the statement of the son of the deceased, who is the informant and the most vital and important witness of this case is concerned. My lord, page 53, Tapas Kumar Muria, the son of the deceased. I do not know the accused persons. But the sentence starts in the chief executive. I do not know the accused persons. I am the informant in this case. The deceased Suromulia is my father. My father has been killed by some persons, and I cannot say who had killed him. This is the son's statement, my lord, with the informant, and on the basis of whose information, 6 accused persons have been implicated. And these 4 are facing trial. And in this trial, the son's statement is, I do not know who has killed my father. On 1910-98, I was told by Bhattakrishna Jena, Subhakar Pradhan, Rajana Porida, and Nityananda Porida that the deceased was killed by somebody and his dead body was lying at the spot. But in the affair, who he has stated that I heard from these persons, the deceased were killed by the accused persons. But here he said that deceased were killed by somebody they have intimated, not naming the accused persons. I went to the spot. I found that the dead body of the deceased was lying before I lost the affair. Lying there. I lost the affair. Your lords may kindly see the discrepancy. I lost the affair at the PS. In the affair, he stated, my lord, I see you here and lodging this affair at the spot. Police officer said, I have not gone to the spot in the night. And here he said, I have given this affair in the police station. These are the inconsistencies, my lord, which is glaring, my lord. Exhibit 4 is the affair lost by me, and Exhibit 4/1 is my signature. then my lord, my statement under section 164 CRPC has also been recorded by the magistrate. Nothing, my lord, because the 164 statement is not substantial evidence. That happened also not marked as an exhibit. So no question of that is no justification of going to 164 statement. Then I have taken the Jima of Luna moped of my father from police after seizure of the same. Exhibit 5 is the Jimanama and exhibit 5/1 is my signature. And interestingly, my lord, most interesting, this witness has not been declared as the hostile, my lord. Right. He's a prosecution witness and the prosecution relies on his statement. He has not been declared as hostile. The son who comes to the court on oath says, I do not know who has killed my father. Nobody has intimated me. And I am the informant in this case. Some unknown person's killed. He has not been declared hostile. So the prosecution is bound to rely on him. Once he has not been declared hostile, man, the prosecution is bound to rely on him and he is the son and the informant. Then your lordship can receive cross-examination. Prasanta Behra and Yudhishthira Rautray were present near the dead body of the deceased. On being asked by me, Prasanta Behra, my lord, is a very important witness, my lord, PW 10, about whom I my lord have mentioned subsequently. Prasanta Behra and Yudhishthira Rautray were present near this dead body of the deceased. My lord, I have been convicted, these two appellants have been convicted solely on the statement of Prasanta Behra. And it is the prosecution case, my lord, that this Prasanta Behra, who had seen that one of the appellant was following them, other accused persons surrounded and assaulted, this Prasanta Behra was also present at this court. And he has, Prasanta Behra and Yudhishthira Rautray were present at this dead body of this deceased. On being asked by me, he asked my lord, on being asked by me, the above two persons expressed their ignorance. Lord, may kindly see, I have been convicted by the evidence of PW 10. PW 10, my lord, and PW 10 also another history I'll make mention before your lordship. PW 10, my lord, and what he said that PW 1 is very much present there. I asked him who was killed my father. He expressed his ignorance. But I have been convicted on the statement of PW 4. And I have filed an application, my lord, today before your lordship. Because in this case, my lord, on merit, my lord, this is 100% case. So therefore, your lordship will decide whether this application will be allowed or not. I have filed an application, my lord, for additional evidence under section 391, which is pending before the previous bench, my lord. My purpose is...
Is that shown in the list?
Pardon?
Is it shown in the list?
Yes, probably it is there.
This is IA number 1 of 2020.
Yes.
So what is your, Mr. Katke, you are appearing?
There, my lord. Your lordship can see this witness, PW 10.
And 1 minute, you are appearing, right?
He has not filed any objection.
No. I have not got the copy even.
No, I
No.
In that case, previous it was listed, already listed.
This is not on the record, Miss. Okay, I will answer that. I can answer that.
Huh?
391 petition of answer that.
No, the copy they will not.
No, but you'll have to give him a copy, sir.
I remember I have given probably it is missing or there may be some miscommunication. But without serving a copy, usually you never file any petition. And it was listed once or twice also before another division bench. This is for the third time it was before lordship. So this objection is raised for the first time. I will serve a copy.
All right. You say IA number 1 of 2020. Counsel, the appellant states that he has filed his application for permission to lead additional evidence at this stage. A copy of the application has been handed over to Mr. Katkia, who needs time for instructions. Next Wednesday?
My lord?
Next Wednesday?
Next Thursday?
Thursday. Next Thursday. Item 23 will take it up Thursday, next Thursday.
My lord, 2 matters in one day.
All right.
1 week.
30th.
1 week.
23rd, item 23 is a take out on a request of counsel for the appellant list on 30th.
Plus, item 23 plus I am solving the written argument on my learned senior also. Sir.
All right.
Okay.
No, this one is on. Oh,
my lord, what? Well, 22 is in the next week, Thursday, my lord.
Yeah, 22 is 30th, 30th. This is 7th July.
Yes, and 23, my lord?
7 July.
5 to 7 days.
7 days.
I'm mobilized.
7 July.
I'm mobilized.
Item 21.
May I please? Lords, I am on VC, Lords.
Yes, Mr. Patel.
Lords, with due respect, I had undertaken to do the matter today, my lords. But I am just making a request. If your lordship will take up 24, my lords, I'll do it. This one, your lordship may give me some more time.
because I have a difficult situation. I have been advised, my lords, to take rest for a month, and this will take some time. I don't want to stress myself.
All right. All right.
So if your lordship adjourns this to a date in July, my lords, I'll be able to do it.
14th July.
Yes, my lords.
All right. 21 you say list. At the request of Mr. Panda, list on 14 July.
Item 24.
Please, your lordship. Here, my lords, there are 5 appellants in total, of whom 2 are dead, my lords. Appellants 1 and 2.
Right.
So the appeal survives only against the 3 other appellants.
Yes.
That is 3, 4, and 5.
Right.
The facts leading to the case are like this, my lords. The appellant number 1, they are 2 brothers, my lords. And there was enmity between the parties, my lords. The present incident is stated to have taken place on 23/10/1996 in the afternoon, and FIR was lodged, my lords, by 7 millions, which led to the registration of the case against the appellants.
Mr. Panda, your connection is not correct. Mr. Panda, we're not able to hear you properly or see you.
There is some difficulty in the connection. Am I visible now, Willis?
Now you are.
Now, my lords, what happened is, I have filed a note in this case earlier. I believe that is there on record.
Yes.
Written
Follow
note.
that note then.
No, I have to make submissions also.
All right.
This FIR is a counterblast to the first FIR lodged by the appellant number 1, who is since deceased.
Right.
That was registered as GR 1347 of 96 and has been marked as Annexure A as an exhibit on behalf of the defense. 3 exhibits have been marked on behalf of the defense. Annexure A is the formal FIR. Annexure A/1 is the plain paper FIR. Annexure B is the charge sheet. And Annexure C and C/1, they are injury reports received on police requisition, my lords, in respect of injuries sustained by deceased appellants 1 and 2 in that case, my lords.
Right.
Now here, this present FIR which was registered against the appellants, I have filed a translated copy of the FIR. If the lord will permit me, I'll place the translation. The informant Manoj Kumar Swai says, has your lordship got the translated version?
Yes.
His informant had on 23/10/1996 gone to Cuttack to see the Dasara immersion. When I returned from Cuttack at about 1:30 o'clock in the day, Vijay Swai, that is appellant number 2, Ajaya, Akshaya and Abhaya, they are 3, 4 and 5, all sons of Dibakar Swai. Dibakara, appellant number 1, had entered into the backyard of our house, and when they were jointly uprooting the fence of our backyard, younger sister Mamata
She is PW8. Vijaya assaulted her and tore her frock. My father Shiva returned home at that time from the fields, and immediately Dibakara, Vijaya and Abhaya got hold of my father. Dibakara with a thenga, Vijaya with an iron rod, and Abhaya with a tangia jointly assaulted him on his head, for which my father fell down bleeding. Seeing this, when I and my younger brother Mahendra went to our father's rescue, Vijaya and Abhaya assaulted both us brothers with rods, and my left hand and both hands of my younger brother have been injured. When my grandfather Hatta protested, Vijaya put him to my father.
Mr. Panda, you are not visible and also not audible.
Treatment at the neurosurgery department of the hospital at Paris. Would your lordship give me an excuse me for a minute, my lords?
All right.
I'm changing my. Have you seen? Am I audible and visible, my lords?
Yes.
Lords, he says, aforesaid accused have
Mr. Panda, again the same problem.
attacked
You're
our
not,
family members,
not visible at all.
for which we have lost affairs with you. But the accused have been- Lords, am I visible now and audible?
Yes, it's visible.
Yes.
Audible both.
Yes, Mr. Panda.
Lords, am I visible now and audible?
Yes, you are. We are not probably audible too.
Cured ass. Lords, am I visible?
You are. I think you're not able to hear us.
Audible also?
Yes.
And he says, today they have very inhumanly assaulted and murdered our father and have thereby endangered our lives. So from this FIR, my lords, what is the prosecution story is that the accused persons were allegedly uprooting the fence of their backyard. And when PW8 protested, appellant number 2 has assaulted and torn her frock. He says that when Sipo, the deceased, returned home, appellant 1, appellant 2, and appellant 5 got hold of him and assaulted on his head. Dibakara is stated to have assaulted with a thenga, Vijay rod, with a tangia. And then he says that the informant himself and PW1, they were also assaulted and sustained injuries. Besides that, their grandfather Hotto was also injured. Now, so far as PWs 1 and 7 are concerned, there is no injury report on record in order to substantiate that they were injured in course of the incident. So far as Dibakara is concerned, there is no incised injury available on the head. And these witnesses PW1, 7, 8, and 9, in their depositions in court, they have made material variations, my lords, from their earlier statements recorded during investigation, both insofar as the assault and also insofar as the injuries that were sustained. Now, my lords, the appellants were all charged under section 447, 323, and 302, read with 34 IPs. As against the appellant number 2, Vijay, a separate charge was also framed under section 354 IPC. The appellants faced trial, my lords, and the trial was before the learned additional sessions judge. Now, because these appellants were all arrested and taken into custody, my lords, after the FIR was registered against them, they could not take steps in order to get the counter case, my lords, tried along with this trial, my lords. And ultimately, my lords, in the counter case, the other accused therein have been acquitted, my lords. So one of them died and the others got acquitted. My lords, if your lordship will look at the impugned judgment, that is at page 11 of the paper book, my lords, begins at page 12. My lords may see at page 13. My plea, the plea of the accused persons, which was that this was a counter to the FIR lodged by appellant number 1, and that it was the informant side which had gone inside our house and committed acts of criminal offences, my lords. That was not discussed in the judgment by the learned sessions judge. At para 3, he simply writes, plea of the accused is that of complete denial. And at page 15, he says, defense examined none without adverting to the documents which the defense filed as defense exhibits, my lords. At the trial, my lords, the prosecution examined 10 witnesses to establish the prosecution story. Out of these witnesses, my lords, the persons who have seen the incident and are eyewitnesses are PWs 1, 7, 8, and 9. They are all siblings, relations of the, being children of the deceased Sipa, my lords. PW 3, 4, 5, and 6 were examined, my lords, as post-occurrence witnesses, and the IO being dead, he could not be examined, and the supervising officer was examined as PW 10. Now, I will invite your lordship's attention to the evidence of the informant first. The informant is PW 7 at page 103 of the paper. PW7 deposes like this. I know all the accused in the dock. On 23/10/96, at about 1:30 p.m., the occurrence took place. On that day, I returned from Cuttack during Dasara. On my arrival, I found accused in front of my house. My sisters Namita and Mamata were obstructed to offense, to which they were not paying any heed. Accused assaulted Mamata and torn her frock. At that time, my father came from our land side. My father protested the assault on my sister, but accused persons abused my father in filthy language. Then he goes on to say, Thereafter, the accused persons assaulted my father. Dibakaro assaulted by bamboo lathi on the head of my father. Thereafter, my father fell down on the ground. Accused Bijaya assaulted by means of an iron rod on the head. Accused Abhaya assaulted him by means of tangia on the right back. Now, your lordship may note, though in the FIR he stated that the deceased was assaulted by all these three persons with these very weapons on the head. Now he says that it is Abhaya's assault by tangia was on the right back. Thereafter, I protested the action of the accused persons. The accused threatened me with dire consequences unless I leave the spot. Thereafter, I came to the PS. When I left, my father was lying in front of our house. By the time while I returned, I found two of my sisters already left to SCB Medical College, Cuttack, with my injured father. 3 days after the occurrence, my father died at SCB Medical, Cuttack. My maternal grandfather, Kudamani, has since expired, who witnessed the occurrence being present at the spot. Exhibit 4 is the written FIR. 4/1 is my signature. I was present during inquest. Exhibit 3/2 is my endorsement. Exhibit 3/3 is my signature. I was examined by police soon after lodging FIR. In cross-examination, my lords, he admits that I am an accused in GR 1347 of 96. That is the FIR Exhibit A and the charge sheet Exhibit B, and have been released on bail. My brother Bijaya is also a co-accused in the said GR case. Now, this Bijaya has to be read as the witness number 1 because Bijaya is the appellant here, my lords, who is since dead. There is no Bijaya being the brother of this witness. I cannot say if GR 1347 of 96 is instituted on the FIR of accused Dibakar. It is not a fact that I, along with my brother Bijaya, on 23/10/96, in between 12:30 to 1 p.m., entered the house of Dibakar, outraged the modesty of his daughter-in-law, and when Dibakar protested, myself and my brother Bijaya assaulted Dibakar and Bijaya, the son of Dibakar. At 12 midnight, I went to the PS Sadar to lodge the FIR. My villagers Lakshmidhar Swai and Uchab Sahu, these are PWs 3 and 4, accompanied me to the PS. I wrote the first portion of the FIR, but the other portions were scribed by Lakshmidhara and Uchaba in the FIR. I read and signed the FIR. I stayed with my SCB Medical Hospital for about 3 days. On 23/10/96 at 3 p.m., I reached the hospital. I came to the PS with Mahendra. From 2 p.m. till I lost the FIR at midnight, I remained at the PS. During our stay at PS, Dibakara and his son Vijay went to the PS. Soon after their arrival at the PS, I lost the FIR. I cannot say if accused Dibakara and Vijay were sent for medical examination from the PS. The medical examination reports I have filed as Exhibit C, which the trial court has not taken note of. Then he says, my house is at the backside of the house of the accused Dibakar. Our courtyard adjoins the thatched house of the accused. Accused have their land behind the thatched house to facilitate them to thatch their own houses. The village road runs in front of the house of the accused. There is a road in between my house and the house of the accused, through which we used to come to the village road. There has been no fencing on the road between my house and the house of the accused. Then we can omit the other portions. Your Lordship may see then paragraph 9 at the next page. At 12 noon, I arrived at Cuttack to witness Dasara coming from my village. My friends Subhas Narayana. We saw meadows at Badambadi and Dodomunde only and returned back. Along with the friends we came. 2 minutes after my arrival, my father came from the land. By the time I reached, the frock of my sister Mamata was already torn. By the time I arrived, only 2 of my sisters were inside the house. None else were present. Before arrival of my father, I collected information of the occurrence that led to the tearing of the frock of Mamata. By the time I arrived, the fence was already uprooted. Fence was consisting of 6 bamboo pieces which were uprooted by that time. Fence was given on a very day during morning hours. So he says that the fencing was done on the very same day of the incident in the morning hours. It is not, then suggestions he has denied. It is not a fact that in absence of the accused, we put the fence, prevented the accused to go to the Barry side, and on being protested by the accused, I, along with my brother Bijay, entered inside the house of the accused, outraged modesty of daughter-in-law of Dibakar, assaulted Dibakar and his son as Dibakar protested. Then with regard to the injuries, my lords, he has said at the next paragraph, my father sustained injuries on his upper side of head, back of neck and chest. He doesn't speak about the Tangia blow which allegedly appellant Abhay had given on the back as he has stated in the chief. Then, my lords, he has denied the suggestions to have not mentioned in the FIR, not stated before the police, that the accused abused his father in filthy language when he arrived and protested the actions of the accused persons, that Mamata protested, that when accused persons assaulted and tore the frock of his sister Mamata, and that Abhaya assaulted by Tangia axe on the back of my father. This is what he has denied. Now your lordship may look at the evidence of Mamata Millars. PW 9 Millars, page 111 of the page. Whereas PW 7 has said that he had gone to witness Dasara, came back, Millars. What Mamata is saying is, on the date of occurrence, at about 1 p.m., my father had been to our field and I was cooking and feeding my brother in our house. My brother had given fence in our homestead land to prevent stray cattle. Vijaya by that time came and assaulted my brother Manoj Swine. This PW7. When my brother asked as to why he was assaulting, Vijaya asked as to why the fence was given. By then my brother told that as there was cattle trend, the fence was given. On hearing this, Vijaya assaulted me. By that time, my father arrived in our house. While we were narrating the occurrence to him, Dibakaro came and suddenly assaulted my father by means of a thenga. Then my younger sister Namita and brother Mahendra, that is PW1, came and tried to lift my father. Vijaya, Abhaya and Ajaya, Akshaya Swine assaulted my brother Mahendra and sister Namita by means of thenga and also pelted stones. Mahendra sustained injury on his head. Then my both brothers went outside to prevent further assault. And my father, when was going to PS to report, Vijaya and Dibakaro assaulted my father. As a result, my father fell down. And when I was trying to lift my father, Vijaya assaulted me and Dibakaro tore my dress and gave fist blow on my back. Then I brought my father in auto to the SCB Medical College Hospital. 3 days thereafter, my father died in the hospital. So the version of the incident which PW8 is giving is a totally different version, my lords, from that of the informant who has himself made improvements and omissions from his FIR. According to this witness, my lords, Manoj was having food which he was serving to him when the incident has happened. She says that Vijay has assaulted her. She says that it was Dibakara who assaulted her father with a thenga, and that Mamata and Maheshwar, Namita and Mahendra, when they came to lift their father, Mahendra and Namita were assaulted by Vijaya, Abhaya and Ajaya and Akshaya. Now there is no injury report in respect of injuries sustained also by Namita or by Mahendra. And her specific evidence, my lords, is that it was Vijaya and Dibakara who had assaulted her father, the deceased, who fell down, my lords. Now in cross-examination, my lords may see what she has stated at paragraph 8 at page 130. My brother Manoj was assaulted, and thereafter my brother, sister and myself were assaulted. We fell down in the courtyard by the assault for 10 to 15 minutes. My father had protested at the time when we were assaulted. All the four accused, sons of accused Dibakara, were pelting stones while my father was protesting. They pelted stones for about 20 to 25 minutes. Stones fell on the person of my father, who sustained injuries on his head and knee due to pelting of stones, and due to the injuries, my father became unconscious. Then she says, Your Lordship may see page 114. She has denied the suggestions made to her in the first line, my lords, of 114. It is not a fact that I have not stated before police that my brother had given fence in our homestead to prevent stray cattle. Vijaya by that time came and assaulted my brother Manoj. It is not a fact that I have not stated before police that when I protested along with my brother, Vijaya assaulted me, that by that time while we were narrating the occurrence to our father, Dibakara came and suddenly assaulted my father with thenga. It is not a fact that I have not stated before police that when my sister Namita and brother tried to lift my father, all the sons of Dibakara assaulted my brother Mahendra and sister Namita by means of thenga and pelted stones, and Mahendra had sustained injury on his head. It is not a fact that I have not stated before police that my both brothers went outside to prevent further assault, and my father, when was going to PS to report, Vijaya and Dibakara assaulted my father. As a result, my father fell down. And when I was trying to lift my father, Vijaya Swami assaulted me. Dibakara Swami tore my dress. Dibakara gave a fist blow on my back. Dibakara is my elder father, with whom we are not pulling on well. It is a fact that I have seen Dibakara and his son Vijaya in the hospital when I was there with my father. Both of them were apprehended by police in the hospital. Both accused Vijaya and Dibakara were sent for medical examination by the police. It's not a fact that as my father and brothers entered into the house of accused and outraged modesty of daughter-in-law of Dibakara, when they protested, they were assaulted by us. It's not a fact that my both brothers were accused in connection with the case. To save ourselves, I am deposing false. Now, Exhibit C, my lord, shows that both the deceased appellants, Dibakara and Vijaya, they had been sent for medical examination on police requisition, and injuries were found on them. And this is admitted by this. And her version about the assault on the deceased is totally at variance with the version of the informant, PW 7 million. Now, the prosecution story, my lord, says that it was Vijaya who had assaulted her and tore her frock. This witness whose frock was torn does not say about that. Despite that, my lords, in the accused statements, my lords, a question has been put to each of the accused persons. That is question number number 37, my lords may see, at page 49 of the paper. The trial court questions each of the appellants. It is found from evidence of PW9 that while she was trying to lift her father, Bijay Swami assaulted her and accused Dibakar tore her dress, gave fist blows on her back, and then she shifted her father in an auto to the SCB Medical College. So this story, my lords, about appellant Bijay, who was separately charged under 354 for outraging the modesty of this witness, my lords. This is not there in the depositions in court. Then your lordship may see the deposition of PW 8, my lords. She is another eyewitness. PW, who was allegedly assaulted and sustained injuries. It's at page 108 of the paper. There she says, from the second line, occurrence took place on 23/10/96 at about 1 in the afternoon, front door of our house. My father had earlier put fence around the frontage of our house to prevent cattle from coming inside. Plus, this witness brings in the fence to the frontage of the house, not the backside of the house. Accused Dibakaro, who is related to me as the elder brother of my father, came there, abused my elder sister, known as Mamata Swami, who happened to be present there. When she inquired why he was rebuking her, he assaulted her and tore her wearing clothes. Other 4 accused are the sons of accused Dibakar. During the aforesaid incident, my father had gone to a field. On his return, he saw the condition of my elder sister, Mamata. House of accused Dibakar is adjacent to our house. My father asked Dibakar why he did so to Mamata. On this, all the 5 accused, being armed with lathi, thenga, crowbar and axe, just in front of their house. Entrance in respect of both houses, that is our house and house of Dibakar, is common. My father was assaulted in front of this common entrance. My father sustained severe bleeding injuries, became senseless and lay there. On seeing the situation and fact, we shouted and called our neighbors in loud voice. Some persons stood at some distance away, saw the incident. They did not come nearby to rescue my father because Dibakar threatened that if anyone would come to rescue, he would be assaulted in similar manner. Otto is my paternal grandfather and was present at this spot and has seen the incident. He expired 2 years after this incident. But expired after 3 days. I was examined by the police. In cross-examination, my lords, paragraph 5 is important. I have 2 brothers. They are PW1 and 7. They were not present at the time of the incident. She eliminates the presence of both the informant and the other witness also. And then she says, as they were not present, I and Mamata took my father to the hospital. There were so many cut injuries in the body of my father, so also roughly 15 lacerated injuries on his body. There were 3 injuries on his head. On seeing the assault on our father, we both sisters became terrified, went inside our house. After departure of the accused at the spot, we again came out and then took our father to hospital. She has denied at that she stated to police that accused Dibakara abused and assaulted Mamata and tore her clothes. That accused Dibakara threatened neighbors who came, saying my father had been wearing pant and shirt. They were stained with blood and torn. The spot was also stained. It's not a fact that I was not present during the incident. It is not a fact that my father had trespassed into the house of the accused and has assaulted them, and that they had lodged an FIR against my father. It is not a fact that the accused had not assaulted my father, and that this is a false case. She does not speak about injuries sustained by her as stated by her sister. She does not ascribe any specific act to any of the other appellants, my lords. And regarding the assault on the deceased also, it is omnibus. The next witness, my lords, is PW1. And this witness, PW8, eliminates the presence of both PWs 1 and 7. PW1 is at page 83. His evidence is that a week before 23/10/96, my father was fencing the courtyard with bamboo to prevent trespass of cattle. On 23/10/96, lords may mark the other witness has stated that the fencing was done on the same day. This witness says that it was done a week before. On 23/10/96, the backer of Vijaya, Abhaya and Akshaya came and uprooted the fence given by my father. Mamata came and protested such action of the accused. Thereafter, Vijaya assaulted her by means of a bamboo and torn her shirt. By that time, my father returned back from our land. Seeing the uprooting of the fence by the accused and assaulting my sister, my father fell down. Accused Vijay threw the bamboo lathi, brought an iron rod. Dibakara came with a lathi. Abhaya came with a indiscriminately dealt by means of the arms they were holding on my father while he was lying on the ground. My father was unconscious, being severely injured. At that time, I and my other brother Manoj were at the spot. We prevented the accused from such assault to my father. The accused chased me to assault. Out of fear, I went to our body side. Thinking my father to be dead, accused fled away from the spot. Now, Millards, the appellants Millards having caused the assault on any other person except on the deceased. But his version also with regard to the injury caused on the deceased by the appellants is not tallying with the version of the others. My lords, in cross-examination, my lords may see page 84 at the last part of the page, 3 lines from the bottom. I used to stay in my uncle's house at village Satbatia. So I cannot say if Dibakar is having his own land behind the thatched house adjacent to our house. The north and south of our house, my father fenced bamboo only 7 days before the occurrence. Then para 7 he says, I am working in Joy Jagannath counter. Debbo Sethi, Babuna Raut and some others are also working with me. I am working there since last 1.5 hours. We used to sell tickets of buses going to Rautala, Jharsuguda and others. I used to work from 10 a.m. to 2 p.m. daily. Since 1996, I am staying at Badamba. So he is not a resident of the place and he admits this in cross-examination. Then, my lords, your lordship may see paragraph 9 of his cross-examination. I, along with my sister Mamta and brother Manoj, were in the house when my father returned back from the land. This fact is not spoken by one of the sisters. Process of uprooting of the fence took for about half an hour. By the time my father arrived, fence was already uprooted. Suggestions, my lords, which have been put to him, they are at page 86 of the paper book, paragraph 10 onwards. He says at para 10, my lords may see, 5th line from the top. The sharp side of the axe was used while assaulting my father. Previous statement sentences, about 8 to 10 blows were given by accused on the head of my father. All the 5 accused persons also assaulted on the chest, waist and leg. When my father fell down on the ground, there was bleeding from his head and other parts of the body. My father was wearing a lungi and underwear, a shirt, a banyan, and was also carrying a towel. These wearing apparels were stained with blood. Para 11, he says, I do not know if I am an accused in GR 1347 of 96, in which Dibakar was the complainant. It is not a fact that on 23/10/96 at about 12:30 p.m., I, along with my brother and father, entered the house of Dibakar, abused his daughter-in-law, and pulled her sari in order to make her naked. And on the protest of Dibakar, he and his son Vijay were assaulted by us. It is not a fact that I, along with my father and brother, entered inside the house of Dibakar and the versions of the 4 eyewitnesses who their versions, the versions are neither consistent with each other nor, my lords, consistent with their previous statements before the police, while the version of the informant is also not consistent with what he had stated in the FIR, which is marked as Exhibit 1. If your lordship will look at page 88 of the paper book, which is the evidence of the doctor, my lords, the evidence of the doctor also belies the version of the eyewitnesses. He has described the injuries, my lords, at page 88, paragraph 2. The external injuries are an abraded confusion of size 7 cm into 6 cm, situated on the left side region, the coronal plane, 8 centimeters above the root of the left ear. There is an abrasion 3 centimeters into 1.5 centimeters, looking reddish brown, situated on the lateral aspect of the left gluteal region, just above the greater center. The third injury, my lords, is an abrasion 9 centimeters into 4.5 centimeters, looking reddish brown in color, again situated on the left gluteal region, 4.5 centimeters behind injury number 2. The fourth injury described are 3 small abrasions looking reddish brown color of size 1 cm into 1 cm each, situated on the right shoulder, outer to the lateral end of the right clavicle and acromion process, 1.5 cm apart from each other. There is no incised injury noted by the doctor, either on the head or any other part of the body of the deceased. to substantiate the prosecution allegation made positions about being made by this appellant number 5 with a tangy ambulance. The internal injuries, my lord, shall I place? The doctor has noted several
Not necessary, sir.
injuries, my lords, on the head.
Not necessary.
In cross-examination, my lords, what he has stated at paragraph 6, I'm sorry, in the chief examination, page iron rod, wooden lathi, the rods of crowbar circumference. In cross-examination, it has been elicited from this witness that incised wounds are only possible by sharp cutting weapons, by sharp edges. At least 2 blows with heavy force can cause injuries on the head. If successive blows are given by means of iron rod of crowbar size, axe and lathis, there is possibility of more severe form of injuries. But this is the evidence on the basis of which these appellants have been convicted. And the trial judge has said that the evidence of these eyewitnesses is corroborated by the post-occurrence witnesses. Now, who are these post-occurrence witnesses? They are PWs 3, 4, and 5. The evidence of PW3 is that when he went to the spot, he saw the deceased lying on the ground being assaulted, and he says that the accused were shouting that nobody should come to the spot. He says that he has seen the incident standing in front of a sweetmeat seller's house. PW4 says that when he heard about the incident, he saw Sibo was senseless, and the 2 daughters, 8 and 9, brought him in a tempo, took him to hospital. He does not say about the presence of PWs 1 and 7. And this has been in cross-examination of this witness, paragraph 5 at page 96. He has stated, on my arrival, I found the tempo standing on the road in front of the house of the injured Sibo. On my entry to the house of Sibo, I found 5 persons in the courtyard, namely Narendra Swine, Uchchava Sahu, Prafulla Swine, Hatta Swine, and 2 daughters of Sibo. He doesn't name this presence of this PW1 or PW7 also. And so far as PW5 is concerned, he says that he saw this is lying on the front veranda of the house of the appellant number 1. Appellant was present, appellants were all present there. They were armed with iron rod and firewood pieces and were threatening with dire consequences. Now, on this evidence, evidence of the witnesses, eyewitnesses, PWs 1, 7, 8, and 9 are consistent and cogent, and he has convicted all. Submission is this. Firstly, my lords, the finding of the trial judge that the evidence of these eyewitnesses is consistent is not correct, as I have tried to impress upon your lordships by placing the FIR and their evidence.
Yes.
None of these witnesses also corroborate each other, even with regard to the assault on the deceased. There is no injury report in respect of any of these witnesses who have stated to have been assaulted and injured to support the fact that they were assaulted or injured during the incident. Secondly, my lords, the trial court has held that the post-occurrence witnesses, they corroborate the version of the eyewitnesses. This again, my submission is not borne out from the record. Thirdly, my lords, the defense plea has neither been discussed nor taken into consideration. The defense plea that this is a counter case, which is apparent from exhibits A, B, and C that the defense appellants were injured during the incident, that their affair was earlier in the version of time, Miller. None of these have been taken into consideration by the learned trial judge. And admittedly, my lords, there is enmity and ill feeling between the parties. And this enmity and ill feeling has led to the false implication of all the appellants, my lords, in this crime.
That's it. All right.
May I please?
Yes.
There are 5 appellants. Appellant number 1 and 2.
In my note, my lords, I have highlighted the differences regarding the prosecution story and the assault, my lords.
Yes, yes.
Of all the witnesses, my lords.
Yes, I've seen, in fact, I've seen
I have
that.
highlighted by subheading them with regard to all the circumstances of the assault, my lords.
Correct.
My lordship can see it in my note.
Yes, yes.
I have made an analysis, firstly, as regards the uprooting of the fence. Secondly, with regard to the tearing of the dress of PW9.
Yes.
Thirdly, with regard to the assault on the deceased.
Yes.
And fourthly, with regard to the assault on PW1 and PW7.
Right. Yes.
Out of 5 appellants, appellant number 1 and 2, both these appellants have expired during pendency of the appeal.
Correct.
And we will also make kind on to paragraph 4 at page 13. It's part of judgment.
Yes.
To prove the offense under.
There is one other thing, my lords, I forgot. Now, all these omissions and contradictions, they have been brought out from the evidence of the supervising officer PW10, my lords. Page 117 and page 118 of the paper book.
Right.
Cross-examination, the IO has admitted that none of these witnesses have stated the versions given by them at the trial. Paragraph 3 onwards.
Right.
Paragraph 3 relates to PW4. Before him, on his arrival house of Sibo, daughters of Sibo had taken Sibo in a tempo to SCB Medical College that in Latin. To Mamata. Paragraph 4, he says, I was for him that he saw the frock of daughter of Sibo torn, and seeing many persons, the accused fled away. Para 5, he has stated, Ajay Singh has examined PW7, Manoj, who has not mentioned in the FIR, and also not stated before him that the accused person abused in filthy language when he arrived and protested the actions of accused, and Nomita protested why the accused assaulted and torn frock of Nomita, and Abhaya assaulted by a tangia on the back of his father. Then so far as PW8 in the next paragraph, Nomita has not stated before him that Dibakara abused and assaulted her, torn her clothes. Dibakara threatened neighbors saying that they would be assaulted. Para 7, Ajay has examined PW9, who has not stated before him that she was cooking and feeding her brother at the time of occurrence, that when her brother had given fence in their homestead to prevent cattle, Vijaya by that time came and assaulted his brother Debo, and that when she protested along with her brother, Vijaya assaulted her. By that time, while they were narrating, Dibakaro came, suddenly assaulted their father by Tenga, that when Nomita and her brother tried to lift her father, all sons of Dibakara assaulted her brother and sister Nomita by means of Tenga, pelted stones, and Mahendra had sustained injuries on his head. that her both brothers went outside to prevent further assault, and her father, when was going to PS, Vijay and Dibakar assaulted her father. As a result, he fell down, and when she was trying to lift her father, Vijay assaulted her. Dibakar gave a fist blow on her back. So all the omissions and contradictions have been put to the eye.
Yes, Mr. Murali.
I was placing paragraph 4 of the judgment at running page 13.
Yes.
To prove the offense under section 447, 302, 323, 34 IPC against the accused person, the prosecution is to establish that the accused persons in furtherance of their common intention committed criminal trespass by entering inside the body of the informant. 2. That the accused persons committed murder by intentionally causing the death of Shiva Prasad Swai. 3. That the accused persons voluntarily caused her to informant Manoj Kumar Swai, his brother Mahendra Kumar Swai, and his grandfather Hattokishore Swai. 4. That the accused Vijay Kumar Swai used criminal force to Mamata Swai, sister of the informant, knowing it to be likely that he would thereby outrage the modesty of said Mamata Swai. Now you will see next page, paragraph, just above paragraph, defense examined none.
Due respect, I am unable to hear my language.
I am placing page 15. He is not able to hear.
Can you refresh your connection? If you can rejoin. Are you able to hear us now? Can you hear us now?
Yes, Milos. Now.
Well, running page 15, just above paragraph 6, defense examined none.
Yes.
Then paragraph 7. In paragraph 7, the trial court dealt with the evidence of PW7 and analyzed the evidence of PW7 at page 16, subparagraph. According to PW7, when he returned home, he found the accused persons in front of his house, and his sisters Namita Swai and Mamata Swai were obstructing the accused person not to uproot the fence, to which they were not paying any heed to it. And by that time, when Shiva Prasad Swai arrived and protested, he was also assaulted by the accused persons Dibakar Swai, Vijay Swai, and Abhay Swai. It is further found from the statement of PW7 that the accused Dibakar Swai to have assaulted Shiva Prasad Swai by means of bamboo lathi, and Vijay Swai by means of iron rod, and Abhay Swai by means of tangia. It is further found from the statement of PW7 the accused Vijay Swai to have assaulted Mamata Swai and torn her frock. The statement of PW7 seems to be corroborated with the affair story. There is nothing contrary found from the statement of PW7 to disbelieve the statement of PW7 in this respect. Now, in paragraph 8, the trial court has dealt with the evidence of PW1, and at page 18 subparagraph, the evidence of PW1 has been analyzed. According to PW1, while accused person Dibakara, Vijaya, Abhaya, and Akshay were uprooting the fence given by the accused Shiva Swai, Mamata Swai, when protested, accused Vijay Swai came and assaulted her and torn her shirt, and thereafter his father Shiva Swai arrived there, and when protested, accused Vijay Swai assaulted him by means of a bamboo lathi on his head, and thereafter accused Vijay Swai threw the bamboo lathi and brought one iron rod, and accused Dibakar and Abhay, armed with lathi and tangia, indiscriminately assaulted the deceased. The statement of PW1 discloses the PW1 to have seen the occurrence. In cross-examination, the PW1 has also stated that the process of uprooting of fence by the accused person took for about half an hour. By the time his father arrived, the fence of the house were already uprooted by the accused person. 10 to 15 minutes after the uprooting of the fence, his father arrived. Further, he has stated that the accused persons were present till his father was unconscious, and thereafter they fled away. All the accused persons were simultaneously assaulting his father indiscriminately. The statement of PW1 also seems to be corroborated with the statement of PW7. Even though this witness was cross-examined at length, there is nothing contrary elicited from his mouth to disbelieve the statement of PW1. Then in paragraph 9, the trial court has dealt with the evidence of PW3. Paragraph 10, then you Lordship can down to paragraph 10 at page 21.
Yes.
The Land Trial Court has dealt with the evidence of PW5. The next page, the analysis, page 22, subparagraph. The statement of PW5 discloses the PW5 to have gone to the place of occurrence on hearing Halla and saw the deceased Shibo Swai on the veranda of the house belonging to accused Dibakar Swai, and accused Dibakar Swai and his sons were also present near the spot, being armed with rod and iron rod and firewood pieces, and were threatening with dire consequences. It is also found the PW5 to have seen the accused person to have left the place on arrival of many other persons, and also Namita to have been crying, and a portion of her frock was torn. And on query was informed the accused persons while uprooting the fence, he protested, for which the accused persons assaulted. The statement made by PW5 in cross-examination shows the PW5 has also seen the accused Dibakar was carrying the piece of firewood, accused Vijay was carrying the iron rod. PW7 and PW1 have also stated the accused Dibakar to have been carrying lathi, and accused Vijay was carrying iron rod and assaulted. So the statement made by PW5 in cross-examination shows the statement to have been corroborated with the statement of other PWs, and from the statement of this witness, it can be said the PW5 to have seen the accused persons armed with lathi and iron rod respectively, and learned the accused person to have assaulted and deceased Shibo Swai. Paragraph 11. And you also can see the analysis of evidence of PWC at page 24, subparagraph. The statement of PW6 also discloses the PW6 to have seen the accused person to have been armed with lathi and iron rod and were threatening to take away their lives, those who will venture to come to the spot. PW6 has also seen accused Dibakar was carrying a wooden piece and others were carrying iron rod. It is also found the evidence the PW6 to have learned from Hattokishore and Mamata the accused persons to have assaulted and deceased Shibo when he protested the uprooting of the fence. Even though this witness is cross-examined at length, nothing could be brought out from his mouth to disbelieve the statement of PW6 in this respect. It is found both the PW5 and 6 seems to have learned the occurrence from Hattokishore Swai, father of the deceased Shibo Swai. The evidence discloses Hattokishore was all along present at the spot, but Hattokishore Swai has not been examined in this case as he died after 1 year of the occurrence. So even though the said Hattokishore Swai has not been examined in this case, non-examination of said Hattokishore Swai in this case cannot create any doubt on the statement of PW5 and PW6 to say that they have not learned from Hattokishore Swai about the assault made by the accused persons. PW8 evidence has been dealt with in para 8, and you will also come to page 26, analysis of our evidence, subparagraph, that is first line, second line. According to the PW8, the accused Dibakar Swai came and abused her elder sister Mamata, and when she protested, accused Dibakar Swai assaulted her and torn the wearing clothes, and when her father arrived and protested, the accused person being armed with lathi, tenga and crowbar brutally assaulted Shibo in front of their house. The statements of the PW8 shows the PW8 to have seen the accused persons assaulting deceased Shibo Swai. Though it has been elicited by the defense, the PWs 1 and 7 were not present at the time of incident, but in view of the statement made by other PWs who have specifically stated the PWs 1 and 7 have to have been present, the statement made by PW8 in cross-examination cannot be utilized to say the PWs 1 and 7 were not present at the time of occurrence. The statement of PWs 1 and 7 seems to be corroborated with the statement of other witnesses, for which it can be said that the PWs 1 and 7 were present at the time of occurrence. Paragraph 13, PW9 evidence has been dealt with. Let's kind on to page 27 bottom, subparagraph. The statement of PW9 shows that when accused Vijay came and assaulted her brother Manoj, and on protest, Vijay assaulted PW9, and when her father came and PW9 was narrating about the occurrence, accused Dibakar came and suddenly assaulted the deceased by means of thenga, and thereafter her sister and brothers and other brothers were also assaulted. And when her father was going to PS to report, he was assaulted by Vijay Swai and Dibakar Swai. As a result, Shibo Swai fell down unconscious with injuries, and PW9 shifted him to the hospital in an auto. Though the PW9 was cross-examined at length, nothing contrary could be brought out on material particulars to disbelieve in this respect. Even though there is some minor discrepancies in the statement of the PW9 that the accused persons assaulted Shiba Swami and accused Vijay to have assaulted her, which is found to be corroborated with the statement of other witnesses, the minor discrepancies found in the statement of PW9 cannot be utilized against the PW9 to say the PW9 to have been falsely alleging against the accused persons. Then in paragraph 14, the evidence of medical officer has been dealt with. Now we will also kind of paragraph 15 at page 31. The seizure list exhibit 6 also discloses the IO to have seized the iron rod, body, crowbar from the house of the accused Dibakar Swami, and also the exhibit 7 discloses the IO to have seized one bamboo and another bamboo body and one torn frock from the front of bedroom of the accused Dibakar. The statement made by the witnesses shows the accused person to have used iron rod and lathi and iron rod are also found to have been recovered from the house of the accused Dibakar, and also the evidence discloses the torn frock of Mamata was lying at the spot, which was also found to have been recovered by the IO. There is nothing contrary found to disbelieve the seizure list in respect of seizure of the articles. From the statement of all the witnesses, it is found that the deceased Siboswami had given fence in his homestead land, but on the date of occurrence, that is on 23/10/96 at about 1:30 p.m., the accused persons came and while uprooting the fence, when they were protested by the PW9, Mamata Swami, she was assaulted by Vijay and the frock of PW9 was torn, and by that time, when Shibaprasad Swami arrived and protested, all the accused persons assaulted deceased Siboswami indiscriminately by means of lathi and iron rod. As a result, the deceased Siboswami fell down, sustaining injuries, and was shifted to SCB Medical College Hospital, where he succumbed to injuries. The evidence also discloses the accused Vijay Swami gave push to Hatakishwar Swami. From the evidence, it is found the prosecution could be able to establish beyond all reasonable doubt the accused person to have assaulted the deceased Siboswami, causing his death, and also the accused Vijay to have assaulted the PW9 Mamata Swami and torn her frock, outraging her modesty. Now, my lord, may kind down to the evidence of PW1 at page 83. Here, my lord, you lords may kindly mark two dates so far as this witness number 1 is concerned. Well, the incident has occurred on 23/10/1996, and this PW1 was examined on 3/12/1998. So this is after more than two years. 2 years. Paragraph 1. I know all the accused persons. Accused Dibakara is my elder father, and others are his sons. On 23/10/96 at about 1:30 p.m. the occurrence took place. I was in my house. 1 week before 23/10/96, my father was fencing the courtyard with bamboo in order to prevent trespass of the cattle. On 23/10/96, accused Dibakara, Vijaya, Abhaya, Akhaya came and uprooted the fence given my father. My sister Mamata came and protested. And this Mamata is PW9. Came and protested such action of the accused person. Thereafter, accused Vijay assaulted her by means of bamboo and torn her shirt. By that time, my father returned back from our land. On seeing the uprooting of the fence by the accused and assaulting my sister, my father protested such action of accused Vijay. Thereafter, accused Vijay gave a blow on the head of my father by means of a bamboo lathi, causing fracture of head. My father fell down. Thereafter, accused Vijay threw bamboo lathi and brought one iron rod, and accused Dibakara came with a lathi, and accused Abhay came with a tangia, and indiscriminately they dealt by means of the arms they were holding on my father while he was lying on the ground. My father was unconscious, being severely injured. At that time, I, along with my brother Manoj, PW7, were at the spot. We prevented the accused person from such assault to my father. The accused person chased me to assault, out of which I went towards our body side, thinking my father to be dead. The accused person fled away from the spot. Well, this evidence of PW1 has been corroborated by PW7. Evidence of PW7 at page 103. My placement.
Yes.
I know all the accused, well, this witness also was examined more than 2.5 years after the incident. He was examined on 10/6/1999.
Right.
Paragraph 1. I know all the accused persons in the dock. On 23/10/96 at about 1:30 p.m. the occurrence took place. On that day, I returned from Cuttack during the Sara. On my arrival, I found the accused persons in front of my house. My sisters Namita and Mamata were obstructing them not to uproot the fence, to which they were not paying any heed. The accused persons assaulted Mamata and torn her frock. At that time, my father came from our land side. My father protested the assault on my sister, but the accused persons abused my father in filthy language. Thereafter, the accused persons assaulted my father. Accused Dibakar assaulted by Bambolati on the head of my father. Thereafter, my father fell down on the ground. Accused Vijay Swai assaulted by means of an iron rod on the head. Accused Abhay Swai assaulted him by means of tangia on the right back. Thereafter, I protested the action of the accused persons. The accused person threatened me with dire consequences unless I leave the spot. Thereafter, I came to the PS. When I left, my father was lying in front of our house. By the time while I returned back, I found two of my sisters already left to SCB Medical College, Cuttack, with my injured father. 3 days after the occurrence, my father died in SCB Medical Cuttack. My maternal grandfather, Kulamani Pradhan, has since expired, who witnessed the occurrence being present at the spot. And this evidence regarding assault by the appellants at paragraph 2, that this has been corroborated by PW5. PW5 evidence is available at page 97.
Yes.
I know all the accused persons in the dock. On 23/10/96, the occurrence took place on hearing halla. I went and found Siboswain deceased on the front veranda of the house belonging to Dibakar Swain. Accused Dibakar and his sons were also present near the spot, being armed with rod and iron rod and firewood pieces, were threatening for dire consequences in case we will go to the spot. When many others gathered, the accused person fled away. Thereafter, we found Namita Swain, daughter of Shiva, was crying and a portion of her frock was torn. On query, father of the deceased informed us that the accused persons, while uprooting the fence, Shiva protested, for which they all assaulted Shiva. Now you can see paragraph 6. Cross-examination, paragraph 6 at page 99.
Yes.
Accused Dibakar Swami was carrying the piece of firewood. Accused Vijay was carrying the iron rod of 2 inches circumference and about 4 feet long. While leaving the spot, the accused person threw the weapon of offences at the spot where Shiva was lying. The spot was bloodstained where Shiva was lying. I have seen bleeding from backside, head and back of Shiva. Shiva was wearing a banyan which was also stained with blood. The wearing lungi of Shiva was also stained with blood.
Now you can summarize.
Yes.
It's homicidal medical evidence. Does it corroborate the eyewitness? This is the main thing you have to ask.
No, medical evidence. No, medical evidence, you also can see PW2 on the page 90, paragraph 6.
Yeah.
And here the medical officer has stated, paragraph 6 at page running page 90.
Yes.
The injuries are possible by iron rod, wooden lathi, rods of crowbar circumference. And all these things have been seized. And in paragraph 7, in cross-examination, the medical officer inside wounds are only possible by sharp cutting weapon by sharp edge. At least 2 blows with heavy force can cause the injuries on the head. If successive blows given by means of iron rod of crowbar size X and lathi, there possibility of more severe form of injury. This PW7. PW7 has stated that accused Abhay Swai assaulted by means of tangia. That is a sharp-edged weapon.
And it's an iron number.
And all admittedly, PW1, 7, 8, and 9, and those are the relatives of the deceased persons.
What about that cross FIR and the defense documents that the injury is on the accused?
Yes. Well, to that extent, I will place reliance upon one judgment.
छोटा ना सकता है
Submitted note. So Mudali, you can put it down in a note.
Yes.
Mr. Panda, anything more?
My lords, I'd just like to point out with regard to Mr. Muduli's version. Now your lordship sees Mr. Mudulis relies on PW1, PW7 and PW5 and says that all of them corroborate each other. Now, if your lordship will look at page number 86 of the paper book.
Yes.
PW1 claims to be an eyewitness who was present at the spot and has seen the incident.
Yes.
What he says at paragraph 10 of page number 87 is this. My lords may see the last part of the paragraph.
Yes.
My father was wearing one lungi, one underwear, one shirt, one banyan, and was also carrying a towel. All these wearing apparels were stained with blood. Now your lordship may look at the evidence of PW5 on which Mr. Mudali placed reliance. PW5 says like this, my lords, at page 99.
Yes.
Paragraph 6. Sibba was wearing a banyan which was also stained with blood. The wearing lungi of Sibba was also stained with blood. Now, my lords may look at PW9, my lords.
Mamata swine.
Yes, my lords. No, sorry, PW8, page 110, my lords. Paragraph 6. My lords may see the middle portion of paragraph 6. It is about 5 lines from the top of that. My father had been wearing pant and shirt. The same were stained with blood and were also torn. Now, my lords, my submission is this. Would your lordship look at page 119 of the paper? This is the forwarding report of the wearing apparels of the deceased, my lords.
Yes.
Number 1, serial 1 is one white full pant containing blood stains. Number 2 is one white full shirt having blood stains. Number 3 is an old torn towel containing blood stains, my lords. They were all collected, your lordship may see, from whom and by whom seized. Wearing of deceased from hospital by SIAKC. My lordship, PW1 was present in the house. He does not know what his father was wearing. If PW5 has come and seen the incident, has he not seen what the deceased was wearing, my lords?
Yes.
And if the learned trial judge says that there is nothing has been elicited in cross-examination, I myself would like to be educated at this stage as to what else is to be cross-examined, how a witness is to be cross-examined, and what is to be elicited. Mr. Muduli has stated before your lordship that every witness corroborates each other. Has the doctor corroborated the alleged Tangia blow said to have been dealt by Obhay with the sharp side, my lords? A Tangia blow on the back, which caused an injury on the back. Where is that injury in the post-mortem report? Does PW2 say anywhere that he has noticed a Tangia blow or an incised wound? The FIR says that the Tangia blow was on the head, my lords.
Yes.
Where is the Tangia blow on the head, my lords? And whereas the trial judge discussed my evidence, my lords, whereas my defense plea been discussed in the entire judgment which was placed before your lordship by my learned friend, has the trial judge ever adverted to exhibits A, B, and C anywhere?
Yes.
And each witness your lordship is seeing is giving a different version with regard to the assault on the backer. PW1 says one thing, PW7 says one thing, PW8 says one thing, PW9 says another thing. They are consistent so far as Dibakara and Vijaya having assaulted the deceased. Where does the evidence bring it to being this common concert of minds between all the appellants, my lords?
Yes. Their presence armed with weapons is confirmed.
Where is my presence, my lord? Presence of the 3 appellants who are now before your lordship. Where is their presence confirmed? No Tangia has been seized, my lords, with which Abhay is said to have assaulted. What about the other 2 appellants, Akshaya and Ajaya? Which witness has stated that they participated in the incident? And if the FIR lodged by Dibakara is previous in point of time, what does the law say, my lords? That a case and a counter case, they have to be tried one after the another by the same court, my lords. What happened to my FIR, my lords? All of us went into custody. Because we are accused in a murder case, no bail was granted, my lords. And we faced this sort of trial before a judge who also said, my lords, that yes, these are the witnesses who corroborate. Now, how does PW5 corroborate, my lords, these witnesses? If Gentala, so Satyanarayana is read, my lords, under what scheme of the Evidence Act can the evidence of PW5 be turned as res geste? It is simply hearsay evidence, my lords, because it has been brought out from the IO that he has not stated all these things before the investigating officer.
Right.
If this is not part of res gestae, my lords, how can PW5 be said to corroborate PW1? And if PW1 was actually present, he is an eyewitness. How does he say that his father was wearing a lungi and a banyan? When from the corpse, my lords, a white pant and shirt has come.
Yes.
The same thing is spoken to by PW5. Where is that torn frock, my lords? Has this witness PW8, has he been shown the frock? That yes, this is the frock which I was wearing and which has been torn. Have these weapons, my lords, been shown to the doctor or shown to any of the witnesses? Can a stick be equated with a firewood, my lords? In Gentala, Vijayavardhan Rao and others was a state of MP, my lords. The Supreme Court says, my lords, that hearsay evidence is not admissible unless it is part of res gestae. And in order to bring it within the ambit of res gestae, the statement has to be recorded immediately. Mr. Muduli says that the witnesses were deposing 2 years after the incident. Your Lordship has seen numerous appeals have been heard before your Lordship. This is a rare instance where a trial has taken place within 2 years of the incident. Normally, trials drag on for years in this state, my lords.
Right.
And if these are witnesses to truth, would they not corroborate each other, at least so far as the assault on the backer? I agree, my lords, that they are interested witnesses. They are family members. But your Lordship will also bear in mind, my lords, that these witnesses are inimically disposed of to each other.
Right.
PW8 says that she was giving food to PW7. Does PW7 corroborate even this aspect? He doesn't.
All right.
And I would rely on, my lords, 2006 volume 10 SCC 601, 2016 volume 16 SCC 418. This is regarding appreciation of evidence of witnesses who are discrepant and who do not support each other also, and as well as their previous versions.
Right.
Now the previous versions have been confronted and brought out from the IO. And these are material aspects, my lords. Your Lordship will agree that enmity is a double-edged sword. And where there is enmity, my lords, and the witnesses are interested, here is a case where your Lordship will see PW1 and 7, they were probably never at this spot. One was staying in his uncle's house, the other chap had gone to Cuttack to see the Dasara Meadow. He comes and both of them come and say that we were there and we have seen the incident. We were present. If you have seen the incident and you were present, my lords, my submission is this. How far is Sadar PS from Urali? PW7 says that he lost the affair at midnight on that day. And the death here has taken place 4 days after the incident. And if my affair is earlier in the point of time, my lords, and this is a counter case, my lords, should not the trial judge have averted to those materials which I proved, which I produced before the court? They were all certified copies. I have been examined by on police requisition, something which is admitted by one of the witnesses, PW9. And merely because Hotto Kishore has said, my lords, where is Hotto Kishore? Hotto Kishore may be dead, my lords, I admit. But if Hotto Kishore is dead, does the statement of Hotto Kishore, has it been 161 statement been proved? under section 32 as a dying declaration to bring it, make it admissible.
All right.
May I place two things? Well, this PW5 is no way related to the family of the deceased.
You can put it in your note, Mr. Mudali.
I am giving my that citation I have got, my lord. I am placing that.
All right.
This is 2012, volume 11, SCC 158. Paragraph 8. This relates to this cover both for a relative witness as well as non-examination of the injured is concerned.
Right.
The land counsel for the paragraph 8 I am placing. The land counsel for the appellant submitted that the witnesses relied on the side of the prosecution. PWs 3, 4, and 5 are relatives of the deceased. Hence, in the absence of other evidence, the conviction of solely based on witnesses related to the deceased cannot be sustained. They also submitted that there is no proper explanation for the delay in lodging of FIR. Though the deceased were alive for 12 hours, no dying declaration was recorded. Finally, they submitted that the prosecution has not offered any explanation for the injuries sustained by the accused persons. In other words, according to them, there was a free fight, and in the absence of proper explanation from the side of the prosecution, the entire story is to be disbelieved. On the other hand, the land counsel appearing for the state submitted that on proper appreciation of evidence and the materials, considering the fact that the eyewitnesses were injured and taking note of all acceptable material, the appellants are convicted under section 302 read with section 34 IPC. Hence, there is no ground of interference. Paragraph 10. It is true that entire prosecution case rests on the evidence of PWs 3, 4, and 5. It is equally true that Nibratri, PW3, who made the complaint to the police, is brother of the deceased.
That will turn on the facts. We'll examine this. We'll examine.
Yes.
All right. Orders reserved.
Maybe I allowed just a minute in reply.
All right.
So far as common intention is concerned, I am placing reliance upon 2022 live law 252.
Why don't you put it in a note, Mr. Mudali? That's better.
Yes.
That way you can give it to him also.
Yes.
All right.
Lords, my only submission is this.
Yes.
Decision on which Mr. Mudali relied, the first decision, is of no help to him.
Yes.
Dispute a related witness or an interested witness is not. But the question is, what is the test of reliability?
Right.
The test of reliability is that the witness should be cogent and consistent. Here, all these persons say that they have sustained injuries. Where are those injuries, my lords? Have they established their injuries? No injury reports on record. None of them were sent for medical examination.
All right. All right. Orders reserved to be open to the parties to file the respective written notes of arguments within 1 week. All right. Thank you.